ಕಾರ್ಯಕ್ರಮ ಇವತ್ತಿನ ಕಾರ್ಯಕ್ರಮ ಶುರು ಮಾಡೋಣ. ಗೌರವಾನ್ವಿತ ನ್ಯಾಯಮೂರ್ತಿ ಡಾಕ್ಟರ್ Rama Jois ರವರ 93ನೇ ಹುಟ್ಟುಹಬ್ಬದ ಆಚರಣೆಗಾಗಿ ಸರಣಿ ಉಪನ್ಯಾಸ ಕಾರ್ಯಕ್ರಮದ ನಾನು ಶ್ರೀ ಎಸ್ ಸಿ ಪಾಟೀಲ್ ವಿಶ್ವಸ್ತ ಹಾಗೂ ಕಾರ್ಯಕ್ರಮದ ಸಂಯೋಜಕರು. ಎಲ್ಲರಿಗೂ ನಮಸ್ಕಾರ. ವಿಜ್ಞಾನೇಶ್ವರ ಪ್ರತಿಷ್ಠಾನ ಮರ್ತೂರು, ಕರ್ನಾಟಕ ಕೇಂದ್ರೀಯ ವಿಶ್ವವಿದ್ಯಾಲಯ ಕಡಗಂಚಿ, ಕಲಬುರಗಿ ಮತ್ತು ಕರ್ನಾಟಕ ಕಾನೂನು ವಿಶ್ವವಿದ್ಯಾಲಯದ ವತಿಯಿಂದ ಗೌರವಾನ್ವಿತ ನ್ಯಾಯಮೂರ್ತಿ ಡಾಕ್ಟರ್ Rama Jois ರವರ 93ನೇ ಹುಟ್ಟುಹಬ್ಬವನ್ನು ಆನ್ಲೈನ್ ನಲ್ಲಿ 5 ಸರಣಿ ಉಪನ್ಯಾಸಗಳು ಅಂದ್ರೆ 26, 27, 28 ಆಗಸ್ಟ್ 3 ಮತ್ತು ಆಗಸ್ಟ್ 5 ಮೂಲಕ ಆಚರಿಸುತ್ತಿದ್ದೇವೆ. ಉಪನ್ಯಾಸಗಳು 26, 27, 28 ಮತ್ತು ಆಗಸ್ಟ್ 3 ಮತ್ತು 5 ವೇಳೆಗೆ. ಇಂದು ಕಾರ್ಗಿಲ್ ಯುದ್ಧ ವಿಜಯ ದಿವಸ. ಹುತಾತ್ಮರಾದ ಯೋಧರಿಗೆ ನಮಿಸಿ ಶ್ರದ್ಧಾ ಸುಮನ ಅರ್ಪಿಸಿ ಕಾರ್ಯಕ್ರಮವನ್ನು ಆರಂಭಿಸೋಣ. ನ್ಯಾಯಮೂರ್ತಿ ಮಡಗಡ್ಡೆ Rama Jois ರವರು ಸರಳ ಸಜ್ಜನಿಕೆಯ ಸಾಕಾರ ಮೂರ್ತಿ, ಸಮಾಜದಲ್ಲಿನ ಬಡವರ ಬಗ್ಗೆ ಮತ್ತು ಪರಿಶಿಷ್ಟ ಜಾತಿ ಪಂಗಡಗಳ ಬಗ್ಗೆ ಅಪಾರ ಕಾಳಜಿ ಉಳ್ಳವರು. ಭಾರತೀಯ ನ್ಯಾಯಶಾಸ್ತ್ರ ಕುರಿತು ಆಳವಾದ ಅಧ್ಯಯನ ಮಾಡಿದವರು. ರಿಲಿಜನ್ ಮತ್ತು ಧರ್ಮದಲ್ಲಿನ ವ್ಯತ್ಯಾಸ ಭಾರತೀಯರಿಗೆ ಮನಗಾಣಿಸಿದರು. ಮೇರು ವ್ಯಕ್ತಿತ್ವದ ನ್ಯಾಯಮೂರ್ತಿಗಳ ವಿಚಾರಗಳನ್ನು ಸಮಾಜದ ಕಟ್ಟಕಡೆಯ ವ್ಯಕ್ತಿಗೆ ಮತ್ತು ಯುವ ಪೀಳಿಗೆಗೆ ತಲುಪಿಸುವ ಸಾಧನವನ್ನಾಗಿ ಅವರ ಜನ್ಮದಿನದ ಅರ್ಥಪೂರ್ಣ ಆಚರಣೆ ಆಯೋಜಿಸಲಾಗಿದೆ. ಸಂತೃಪ್ತ ಮತ್ತು ಸಮೃದ್ಧ ಪಾರಿವಾರಿಕ ಜೀವನ ನಡೆಸಿದವರು. ಅವರ ಜನ್ಮದಿನದ ಸಂದರ್ಭದಲ್ಲಿ ಅವರಿಗೆ ಪ್ರಿಯವಾದ ಭಾರತೀಯ ಕಾನೂನು ಶಾಸ್ತ್ರ ಜೊತೆಗೆ ಪ್ರಸ್ತುತ ಕಾನೂನು ಅಧ್ಯಯನ ಕುರಿತಂತೆ ತಜ್ಞರಿಂದ ಉಪನ್ಯಾಸಗಳನ್ನು ಏರ್ಪಡಿಸಲಾಗಿದೆ. ಕಾರ್ಯಕ್ರಮದಲ್ಲಿ ಇಂದು ಉಪನ್ಯಾಸ ನೀಡಲು ಕರ್ನಾಟಕ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ವಿಶ್ರಾಂತ ನ್ಯಾಯಾಧೀಶರಾದ ಹಾಗೂ ವಿಶ್ರಾಂತ ಉಪ ಲೋಕಾಯುಕ್ತರಾದ ನ್ಯಾಯಮೂರ್ತಿ ಸುಭಾಷ್ ಬಿ ಆದಿಯವರು ಮತ್ತು ಅಧ್ಯಕ್ಷತೆ ವಹಿಸಲಿರುವ ಅಸ್ಸಾಂನ ಕುಮಾರ್ ಭಾಸ್ಕರ್ ವರ್ಮಾ ಸಂಸ್ಕೃತ ಮತ್ತು ಪುರಾತನ ಅಧ್ಯಯನ ವಿಶ್ವವಿದ್ಯಾಲಯದ ಮಾನ್ಯ ಕುಲಪತಿಗಳು, ಕಲಬುರಗಿಯವರಾದ ಪ್ರೊಫೆಸರ್ ಪ್ರಹ್ಲಾದ್ ಆರ್ ಜೋಶಿ ಅವರು, ಕರ್ನಾಟಕ ಕೇಂದ್ರೀಯ ವಿಶ್ವವಿದ್ಯಾಲಯ ಕಡಗಂಚಿ, ಕಲಬುರಗಿ ಮತ್ತು ಕರ್ನಾಟಕ ಕಾನೂನು ವಿಶ್ವವಿದ್ಯಾಲಯದ ಮಾನ್ಯ ಕುಲಪತಿಗಳು ಹಾಗೂ ಉಪನ್ಯಾಸಕರು, ವಿದ್ಯಾರ್ಥಿಗಳು, ನ್ಯಾಯಮೂರ್ತಿ Rama Jois ರವರ ಪರಿವಾರದ ಅಭಿನವ ಬಳಗದ ಸದಸ್ಯರು, ವಿಶ್ರಾಂತ ರಾಜ್ಯಸಭಾ ಸದಸ್ಯರು ಮತ್ತು ಪ್ರತಿಷ್ಠಾನದ ಮಾನ್ಯ ಅಧ್ಯಕ್ಷರಾದ ಶ್ರೀ ಬಸವರಾಜ್ ಪಾಟೀಲ್ ಸೇಡಂರವರು, ವಿಜ್ಞಾನೇಶ್ವರ ಪ್ರತಿಷ್ಠಾನದ ಹಿರಿಯ ವಿಶ್ವಸ್ತರು, ಉಪನ್ಯಾಸ ಸರಣಿಗಳ ಪ್ರೇರಕರಾದ ಶ್ರೀ ಮಹಾದೇವಯ್ಯ ಕರ್ದಾಳಿ ಅವರು, ಶ್ರೀ ಸುರೇಶ್ ಬುಲ್ಬುಲಿ ಅವರು, ವಿಶ್ರಾಂತ IAS ಅಧಿಕಾರಿಗಳಾದ ಶ್ರೀ M ಲಕ್ಷ್ಮೀನಾರಾಯಣ ರವರು, ಮರ್ತೂರಿನ ಶ್ರೀ ಗುಂಡಪ್ಪ ಕುಂಬಾರ್, ಡಾಕ್ಟರ್ ವಾಸುದೇವ್ ಸೇಡಂರವರು, ಬೆಂಗಳೂರಿನ ನ್ಯಾಯವಾದಿಗಳಾದ ವಿಕ್ರಮ್ ಪಡ್ಕೆಯವರು, ತುಮಕೂರು ವಿಶ್ವವಿದ್ಯಾಲಯದ ಪ್ರೊಫೆಸರ್ M ಕೊಟ್ರೇಶ್ ಅವರು, ಮರತೂರಿನ ಡಾಕ್ಟರ್ ಬಸವರಾಜ್ ಪಾಟೀಲ್, ಶ್ರೀ ಯೋಗೀಶ್ವರ್ ಯಾಜ್ಞವಲ್ಕ ಸಮಿತಿ ಅಧ್ಯಕ್ಷರು, ಕಾರ್ಯಕ್ರಮದ ಸಂಯೋಜಕ ಹಿರಿಯ ವಕೀಲರಾದ ಅಮಿತ್ ಕುಮಾರ್ ದೇಶಪಾಂಡೆ ರವರು, ವಿಶ್ವವಿದ್ಯಾಲಯಗಳ ಮಾನ್ಯ ಕುಲಪತಿಗಳು, ಮಾನ್ಯ ನ್ಯಾಯಾಧೀಶರು, ಕಾನೂನು ಮಹಾವಿದ್ಯಾಲಯದ ಮತ್ತು ಅನ್ಯಾನ್ಯ ಮಹಾವಿದ್ಯಾಲಯಗಳ ಪ್ರಾಚಾರ್ಯರು, ಉಪನ್ಯಾಸಕರು, ವಿದ್ಯಾರ್ಥಿಗಳು ಹಾಗೂ ನ್ಯಾಯವಾದಿಗಳು ಉಪನ್ಯಾಸ ಕಾರ್ಯಕ್ರಮಕ್ಕೆ ಸೇರಲಿದ್ದಾರೆ. ಕಾರ್ಯಕ್ರಮದಲ್ಲಿ ಭಾಗವಹಿಸಿದ್ದಾರೆ. ಅವರೆಲ್ಲರಿಗೂ ಸುಸ್ವಾಗತ. ಇಂದಿನ ನಮ್ಮ ಕಾರ್ಯಕ್ರಮ ಅತಿಥಿ ಉಪನ್ಯಾಸಕರನ್ನು ಅಧ್ಯಕ್ಷರನ್ನು ಪರಿಚಯ ಮಾಡಿಸಲು ಸ್ವಾಗತಿಸುವ ಶ್ರೀರನ್ನ JNR ಕಾನೂನು ಮಹಾವಿದ್ಯಾಲಯದ ಪ್ರಾಚಾರ್ಯ ಶ್ರೀ ಶರಣಗೌಡ ಪಾಟೀಲ್ ಆಮಂತ್ರಿಸುತ್ತೇನೆ.
ಎಲ್ಲರಿಗೂ ನಮಸ್ಕಾರಗಳು. Good evening to all for being here with us today on the eve of Justice Dr. Rama Jois Memorial Online Lecture Series 2023. Indeed, it gives me immense pleasure to welcome you all. First of all, I would like to heartily welcome Honorable Justice Subhash B Adi sir, former Judge, High Court of Karnataka and former Upalokayukta Karnataka. Sir has, after completion of their LLB graduation, enrolled in 1978 as an advocate and started practice in the High Court of Karnataka. Sir has practiced in several branches including civil, criminal, constitutional, and labor matters. Furthermore, Sir has specialized in the subjects like land reforms, and local bodies. Sir was appointed as an additional judge of Karnataka High Court on 6th January 2006 and elevated as a permanent judge on 1st March 2007. 2013ರವರೆಗೆ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ನ್ಯಾಯಮೂರ್ತಿಗಳಾಗಿ ಸೇವೆ ಸಲ್ಲಿಸಿ ನಿವೃತ್ತಿಯಾದ ನಂತರ ಮುಂದೆ 2013ರಲ್ಲಿ ಕರ್ನಾಟಕ ರಾಜ್ಯ ಉಪಲೋಕಾಯುಕ್ತರಾಗಿ ಗೌರವಾನ್ವಿತ ನ್ಯಾಯಮೂರ್ತಿಗಳು ನಿಯುಕ್ತಿಗೊಂಡರು. ಇವರ ಸೇವಾವಧಿಯಲ್ಲಿ ಆಡಳಿತದಲ್ಲಿ ಪಾರದರ್ಶಕತೆಯನ್ನು ತರುವುದಕ್ಕಾಗಿ ಕೆಲವು ಕಟ್ಟುನಿಟ್ಟಿನ ಕ್ರಮಗಳನ್ನು ತೆಗೆದುಕೊಂಡಿದ್ದು ಇಂದಿಗೂ ಜನಮಾನಸದಲ್ಲಿ ನೆನಪಿನಲ್ಲಿದೆ. ಇಂದು ಸಿಗ್ನಿಫಿಕೆಂಟ್ ರಿಫಾರ್ಮ್ಸ್ ಏರಿಯಾಸ್ ಅಂಡ್ ಟ್ರೆಂಡ್ಸ್ ಇನ್ ಕ್ರಿಮಿನಲ್ ಲಾ ಈ ವಿಷಯದ ಮೇಲೆ ಉಪನ್ಯಾಸವನ್ನು ನೀಡಲಿರುವ ಗೌರವಾನ್ವಿತ ನ್ಯಾಯಮೂರ್ತಿಗಳಾದ ಶ್ರೀ ಸುಭಾಷ್ ಬಿ ಅಡಿ ಸರ್ ಅವರಿಗೆ ನಮಸ್ಕರಿಸುತ್ತಾ ಈ ಉಪನ್ಯಾಸ ಮಾಲಿಕೆಗೆ ಗೌರವಪೂರ್ವಕವಾಗಿ ಸ್ವಾಗತ ಕೋರುತ್ತೇನೆ. ಹಾರ್ಟ್ಲಿ ವೆಲ್ಕಮ್ ಯು ಸರ್. ಹಾಗೆ ಇಂದಿನ ಉಪನ್ಯಾಸ ಮಾಲಿಕೆಯ ಅಧ್ಯಕ್ಷತೆಯನ್ನು ವಹಿಸಿಕೊಂಡಿರುವ ಗೌರವಾನ್ವಿತ ಪ್ರೊಫೆಸರ್ ಪ್ರಹ್ಲಾದ್ ರಾಮಾಚಾರಿ ಜೋಶಿಯವರು ಮೂಲತಃ ಕಲಬುರಗಿಯವರಾಗಿದ್ದು ಇಲ್ಲಿಯ ಪ್ರತಿಷ್ಠಿತ ಶಿಕ್ಷಣ ಸಂಸ್ಥೆಯಾದ ನೂತನ ವಿದ್ಯಾಲಯದ ವಿವಿಧ ಪ್ರಕಲ್ಪಗಳಲ್ಲಿ ಅಧ್ಯಯನ ಮಾಡಿದ್ದಾರೆ. ಕಲಬುರಗಿ ವಿಶ್ವವಿದ್ಯಾಲಯದಿಂದ ಸಂಸ್ಕೃತದಲ್ಲಿ ಪ್ರಥಮ ರ್ಯಾಂಕಿನೊಂದಿಗೆ ಸ್ನಾತಕೋತ್ತರ ಪದವಿಯನ್ನು ಪಡೆದ ನಂತರ ರಾಷ್ಟ್ರೀಯ ಸಂಸ್ಕೃತ ವಿದ್ಯಾಪೀಠ ತಿರುಪತಿಯಲ್ಲಿ ಸಂಸ್ಕೃತದಲ್ಲಿ BEd ಮತ್ತು MEd ಅನ್ನು ಪ್ರಥಮ ಶ್ರೇಣಿಯಲ್ಲಿ ಉತ್ತೀರ್ಣರಾಗಿದ್ದಾರೆ. ನಂತರ ಅದೇ ವಿಶ್ವವಿದ್ಯಾಲಯದಲ್ಲಿ ಅಧ್ಯಾಪಕರಾಗಿ ಸೇವೆಗೆ ಸೇರಿದರು. ಸರ್ ಹ್ಯಾಸ್ ಥಾಟ್ ಆಲ್ ಮಾಡರ್ನ್ ಸಬ್ಜೆಕ್ಟ್ಸ್ ಇನ್ ಸಂಸ್ಕೃತ್. Based on their vast teaching experience of 23 years, Sir has written 6 books. Honorable Professor Prahlad R. Joshi Sir is having administrative experience also. ಪ್ರಸ್ತುತ ಗೌರವಾನ್ವಿತರು ಆಸಾಂನ ನಲ್ಬಾರಿಯ ಕುಮಾರ್ ಭಾಸ್ಕರ್ ವರ್ಮಾ ಸಂಸ್ಕೃತ ಮತ್ತು ಪುರಾತನ ಅಧ್ಯಯನ ವಿಶ್ವವಿದ್ಯಾಲಯದ ಕುಲಪತಿಗಳಾಗಿ ಸೇವೆ ಸಲ್ಲಿಸುತ್ತಿದ್ದಾರೆ. ಕಲ್ಯಾಣ ಕರ್ನಾಟಕದ ಕೀರ್ತಿಯನ್ನು ದೇಶಾದ್ಯಂತ ಪಸರಿಸಿರುವ ಗೌರವಾನ್ವಿತ ಪ್ರೊಫೆಸರ್ ಪ್ರಹ್ಲಾದ್ ರಾಮಾಚಾರಿ ಜೋಶಿ ಅವರಿಗೆ ನಮಸ್ಕರಿಸುತ್ತಾ ಈ ಉಪನ್ಯಾಸ ಮಾಲಿಕೆಗೆ ಗೌರವಪೂರ್ವಕವಾಗಿ ಸ್ವಾಗತ ಕೋರುತ್ತೇನೆ.
ನಮಸ್ಕಾರ ಸರ್, ಧನ್ಯವಾದ.
ಈ ಉಪನ್ಯಾಸ ಮಾಲಿಕೆಯಲ್ಲಿ ಪ್ರಾಸ್ತಾವಿಕ ನುಡಿಗಳನ್ನಾಡಲಿರುವ ಪರೋಪಕಾರಂ ಇದಂ ಶರೀರಂ ಎನ್ನುವಂತೆ ಈ ಭಾಗದ ಕಲ್ಯಾಣಕ್ಕಾಗಿ ಹಗಲಿರುಳು ಶ್ರಮಿಸುತ್ತಿರುವ ಸರಳ ಸಜ್ಜನಿಕೆಯ ವ್ಯಕ್ತಿಯಾಗಿರುವ ಗೌರವಾನ್ವಿತ ಶ್ರೀ ಬಸವರಾಜ್ ಪಾಟೀಲ್ ಸೇಡಂ, ಅಧ್ಯಕ್ಷರು ವಿಜ್ಞಾನೇಶ್ವರ ಪ್ರತಿಷ್ಠಾನ ಟ್ರಸ್ಟ್, ಇವರಿಗೂ ಸಹ ನಮಸ್ಕರಿಸುತ್ತಾ ಗೌರವಪೂರ್ವಕವಾಗಿ ಈ ಉಪನ್ಯಾಸ ಮಾಲಿಕೆಗೆ ಸ್ವಾಗತಿಸುತ್ತೇನೆ. I also welcome all the office bearers of the Vijnaneshwara Pratisthana Trust Martur. I also welcome Vice Chancellor, Registrar, Professors, faculty members, students of Central University of Karnataka and Karnataka State Law University Hubli. I also welcome all the legal luminaries, advocates, and coordinator of this lecture series. I also welcome Sri Mahadevaya Karadali sir, who is the backbone of this event. I also welcome all the principals, staff members, and students of all the affiliated law colleges to the Karnataka State Law University. And I thank for providing this opportunity to me. Thank you very much. Sir,
ನ್ಯಾಯಮೂರ್ತಿ ಸುಭಾಷ್ ಆದಿ ಅವರು ತಮ್ಮ ಉಪನ್ಯಾಸವನ್ನು ಆರಂಭಿಸಬೇಕಾಗಿ ವಿನಂತಿ.
Thank you, one and all. Hope I'm able to.
Yes, it is clear.
Hello?
Sir. ಸರಿ ಇದೆ ಸರ್, ಸರಿ ಇದೆ, ಕೇಳ್ತಾರೆ, ಆಡಿಯೋಬಲ್.
Okay. Today's subject chosen before I could commence my speech, I recollect my memories of a great legend and jurist, Sri Justice Rama Jois, Dr. Justice Rama Jois, before whom I had an opportunity to practice also. One of the greatest jurists on constitutional law, service law, and comparison between the religion and the constitutional laws. His books I have read, many books I have read it. And it is a great appreciation that in the name of Dr. Justice Rama Jois, the lecture series are arranged by the Vijnaneshwara Trust, Central University and Law University. Thank you for inviting me and to make me to speak on the significant reforms area and trend in criminal law. Now, before we begin the significant reforms area, let me know about the criminal justice system. Now, everyone thinks that the criminal justice system is something like a criminal law and court. Criminal justice system in India was existing in Vedic time also. It traces back to 7,000 years, and before 3000 BC, there were many laws, and particularly during the time of Chandragupta, a best juris system was prevailing. Over the time, the system was changed, and there were different penal laws depending upon the ruler of the province. Nevertheless, having regard to the time constraint and the present circumstances, the significant reforms area, we need to understand what is criminal justice system, what is criminal law, and what is criminology. Now, anything that is prohibited and punishable, it constitutes a criminal law. And criminology is a scientific study of a non-legal aspects of crimes, delinquency, including the causes, corrections, and preventions, etc. Criminal justice system, there are stakeholders like accused, police authorities, other authorities, criminal courts, prosecution, prison authorities, juvenile reform centers. And in connection with the criminal justice system, we have laws also, statutory laws defining the offenses, prescribing the punishments, such as the IPC, Prevention of Corruption Act, Food Adulteration Act, many acts, coupled with procedural law, criminal procedure, coupled with the evidence law. Who are involved in the criminal justice system, like accused, then the police, then the prosecution, then the court, apart from the authorities also in private complaints also. Now, accused and the victim, complainant as well as victims. Now, offenses also, it may be against the body, it may be against the property, it may be against the state or religion or moral prohibition, political offenses, many offenses. It involves prevention, reformative, prevention by means of a punishment, prevention by means of rehabilitation, and social reforms, etc., etc. The other authorities who are involved in is the police authority, then the prosecution, then the court, then the prison authorities, and others. Now, what is the reform that today it is necessary? What specific reforms we can bring? What specific reforms we can think about? Now, first foremost comes is in a criminal justice system is based on investigation, based on a complaint and investigation. It is said that 80% of the criminal trial is more dependent on the quality of investigation. Now, investigation is by the investigating agencies. It may be police agency or any other authority. Now, standard of investigation, if you look at the standard of investigation and present changing circumstances in the crimes, today crime is not confined to domestic. Crime can be committed from elsewhere, not only necessarily in the place where offense has taken place, etc. It can be committed from a distant place. So that today's whether the investigation agency is well equipped to move with the changing circumstances. For example, standard of investigation is more important. The prosecution and the criminal trial is dependent on the quality of investigation. For example, if you take today's information technology and the crimes happening, we may call it as a cyber crimes. Now, investigation agency, if it is not equipped with the knowledge of the cyber law or the information technology, if it is not equipped well with the particular nature of investigation, it is not the investigation of regular traditional way of recording an evidence or anything. Tracing of a accused on the basis of the information, tracing of the crime committed and the laws related. So the quality of investigation is dependent on the knowledge of the crime and the offense committed and the relevant circumstances connected with it. Now, proper knowledge of evidence, proper knowledge of a procedure and specific laws, expertise in the information technology, expertise in specific the offenses committed in specific laws. These are various methods which needs to be. But by and large, the police officers trained, physically trained and mentally also trained in some extent. But having regard to the today's crimes, having regard to the nature of crimes that are forthcoming day to day, the police officer investigating the crime must have a complete knowledge of such nature and the technical knowledge, particularly technical knowledge, tracing out. I had an occasion to participate in one of the conference relating to, maybe it was a Hyderabad investigation on Satyam scam. Now there was hidden account which was not traced even by the investigating agency, only the expert agency which came and investigated. Now how is the hidden account were to be traced? How? Because all the softwares were broken, all the CDs were broken, but the technology was so good. The technical expertise could able to trace the hidden account and the accused was tried. So the investigation agency today needs to be trained appropriately, and only the expert can handle the particular kind of offense. It is not general, and every inspector or every sub-inspector can handle all the cases. So the expertise in particular law, expertise in particular technology, expertise in the information. So such a nature or such changes are necessary for the purpose of investigation, because that is the foremost important for the purpose of criminal trial. So the reforms necessarily for the investigation agencies. So for example, recently we had a train accident. Now there was a question whether CBI can investigate, because it is a technical aspect. So CBI was supported by a well-renowned expertise on technical expertise who assisted them. So there need to be a team of investigation which should have all the parameters of the technical knowledge, of the legal aspect, of the other collection of procedure law, etc. Because the criminal trial, you know, all of you know that there is still we have a ground of benefit of doubt. If there is a benefit of doubt, even the accused can be left free. So the perfection of investigation depends on the accumulated knowledge, complete knowledge of the nature of crime committed by the accused. So apart from this, the investigation also requires the fastest, expediting the investigation is more important. Now, expediting the investigation also depends on how fast the investigating officer collects the evidence. For example, if we come across registration of FIR at a delayed, though the complaint is received, but the delay in registering FIR. So that the things which need to be collected, the evidence which need to be, as per the criminal procedure law, there is a necessity that the investigating officer immediately, the moment he gets the information of the offense committed, he must rush to the spot to collect the evidence. Now, as the investigation officer, if he delays in going to the spot or collecting the evidence, there is a chance of destroying the evidence. If the evidence is not available, the entire trial becomes futile. So, the necessity of receiving the complaint, immediately acting on the basis of the complaint, collecting the evidence at the earliest, and completing the investigation at the earliest, that is more important. That the more the delay, more that the evidence there will be the possibility of the erosion of the evidences. So, in addition to this, during the course of the investigation, what is necessary is to protect the witnesses also. Protection of witnesses, because there will be a threat for the witnesses coming forward and speaking the truth. So the investigation agency must ensure their safety, security, and also protection of their identity. So these are all circumstances which need to be taken care during the course of the investigation, because when a charge sheet is filed, because that becomes the basis for the purpose of criminal trial, even for prosecutor also. So proper knowledge of the evidence, proper importance of the evidence, then securing them, protecting them, and expediting the investigation with all the expertise behind him. Then only it is possible to give proper charge for the purpose of trial. Next comes is the prosecution. Once there is a charge sheet and once the charge is framed, the prosecutor takes the role to prosecute the crime, prosecute the case. Now, the prosecutors equally is important that he has a sound knowledge of criminal law. He has a sound knowledge of all the substantive law, procedural law, and evidence. And only with this background, a prosecutor, if he effectively presents before the court will feel the best assistance from the prosecution, and there is a possibility of the court convicting the accused. Today, what we are hearing is the percentage of conviction has come down. Now, the percentage of conviction has come down, maybe the faulty investigation, maybe the faulty prosecution, or maybe the witness not coming forward before the court for various reasons. So these circumstances, by and large, are necessary to be reformed and protect all the protection of the evidences, protection of the witnesses need to be done during the course of the trial and post-trial also. Now, the prosecutor role comes once the charge sheet is filed before the court. Now, the prosecutor presentation during the course of the trial and the evidence, leading of the evidence, having background of the technical knowledge, because if he does not have that technical knowledge, particularly crimes which we are now facing, he must be in position to lead such evidence which will appeal to the court, and in the cross-examination, it is not dislodged. So the role of prosecution is also equally important. Now, next comes is the court. Based on the evidence, court has to decide. There is then one part of the defense also. Now, accused has a right under the Constitution and as well as under the Criminal Procedure Code. Either he may choose to defend himself by leading evidence also, he may not. But entirely burden is on the prosecution to prove the guilt beyond reasonable doubt. Now, many times the courts will acquit the accused based on the reasonable doubt or doubt beyond the doubt which is beyond the in such a cases. Now, the yardstick, what is the doubt that the court, how the court doubts the prosecution case. Now, beyond the reasonable doubt is a thing whether it is a discretionary power of the court what is the degree of the discretion in understanding the appreciation of the evidence? Now, beyond the reasonable doubt, particularly, now some cases have been decided by the Supreme Court and High Courts also. Many cases have come on that aspect. It is said that when the evidence is appreciated by the court and evidence, if the session judge or the magistrate creates a doubt that whether he can accept the evidence or not, he doubts the prosecution case, and if maybe in terms of percentage, if he feels that it is 50% there is a case for the prosecution and still there is a doubt, he may lead to acquit the accused. So these parameters, when appreciating the evidence and based on that appreciation, the magistrate or the session judge creates a doubt in his mind that the prosecution is not fully proved. The case is not fully proved. Guilt is not fully proved. Now he creates a doubt. If the doubt, if he feels that it is a reasonable doubt, he leads to the acquittal. But what are now commonly the courts are facing is, now what is the degree of appreciation of a case of the prosecution at the preliminary stage? For example, we have got two kinds of the procedure. One now based on a complaint, private complaint, and another based on a police complaint, police FIR. And similarly, in other cases also different laws, special laws. Now, in cases where the police cases, now at the stage of the framing of a charge or even before framing of it, whether it is a 438 or 439, bail becomes one of the major aspect where the courts are concerned. Now, what is the degree of appreciation at the time of granting a bail? Whether courts can go into the details of the crime committed and consider the evidence and find out whether the accused, or whether the court has to use its discretion. Now, discretion, parameters of discretion is not defined anywhere. But nevertheless, at the stage of bail, one has to know that the gravity of the offense, background of the offender, social impact, the impact on the society, all circumstances. It is not a stage, it is a preliminary stage. It is not a stage where courts need to go into the details of the prosecution case, whether likely to convict or otherwise, whether he is could be acquitted. But depending upon the gravity of the offense, depending upon the accused background, depending upon the effect on the society on a release of accused. So these are the circumstances which need to be considered at the stage of bail. Now, without going into details and venturing into giving findings on what could not be. Now, I will not comment on that, but many times the bail matters will have certain effect on the society also. Now, there are other aspects during the course of the trial. The courts considers the prosecution case. Now, prosecution case, you have an elaborate procedure. We have a very elaborate procedure. Now, there is a debate now on the question of elaborate procedure law in India, and recently what in the France, what happened, how the trials are conducted. Now, here there is a feeling that the accused are scot-free by the general public feeling, it is accused are scot-free. Accused are not caught, accused are not arrested. So, it is not dependent on the person involved or personality. It must be based on the gravity of the offense, accused background, and its effect on the society, apart from the nature of the crime. So circumstances have to be noticed, and there has to be some kind of reforms. There has to be some guidelines for the purpose of even granting bail in generally. So the discretion power that is there in the magistrate court or the session court has to be utilized very sparingly and properly. Now, the punishment area when the court comes to the finding that the guilt is proved by the prosecution. Now, we know the criminal law, particularly IPC or any other special law where there is a punishment prescribed. Punishment varies. It may be by means of a fine or by means of a imprisonment. Now, question is, when we can impose fine, when we can imprison. In case of imprisonment, what is the extent? Now, if it is from 2 years to 5 years, now when can be 5 years, when can be 2 years, when can be 3 years, or when can be 4 years? Now, here it is not a question of a discretion of a magistrate or a session judge, but it is always based on the nature of crime, gravity of the offense, impact on the society, and background of the accused has to be taken into consideration apart from the various other aspects of the evidence involved in, and not by means of taking a degree of discretion and granting a lesser or higher punishment. These are also commented of many times by the Supreme Court also. So these things which are now prevailing in the judicial system, criminal justice system, is one aspect. The reforms that the other areas which require. Now we talk about reformative method. Today, every country, for example, it is not only India, most of the countries are overfilled by the accused. There is difficulty of even accommodating the accused in the prison. Now, what can be done in such a circumstances? Now, time and again, you might be reading that under trial, there are 70% of the accused, under trial accused, are languishing in the jail. Now, is it the violation of the violation of the fundamental right of a person, life and liberty, or is it the mistake of the court? Is it the mistake of the prosecution? Now, languishing, there were cases where more than 20 years the under trials were in the prison. Now, how to ensure that the accused gets a justice? Justice in the sense his trial is completed in a time frame. Now, this is the area where there is a need for debate and discussion to bring the parameters or the limitation for a trial. Now, there are some laws which prescribes the limitation, but in criminal justice system, particularly when procedural law is so elaborate, there will be occasion for adjourning the matter for various reasons in between. But if the under trial stays years together and ultimately if he is acquitted, who will account for his personal liberty and the time lost in imprisonment? These are the circumstances where we need to look for a reforms in the investigation, in the prosecution, in the criminal trial by the court, ensuring that no accused should face the trial for more than particular period. Within that period, he must get a justice, acquittal or conviction, whatever be it. But if we go by the system which we are now having, now 70% of the under trial still languishing in the jail for years together, and ultimately if he is not found guilty, his life and liberty, his personal liberty is defeated. There is no method of compensating. Now, this area is also required reforms based on a debate and based on the experts who are there in the realm of affairs. So, this area, by and large, I personally, on my experience, it is not based on any thesis or anything, experience, that there is a need for ensuring speedy investigation, speedy trial, and ensuring the liberty of a person, whether he is a convict or acquitted, he must get justice within a time frame. Otherwise, we will be not answering to his right and liberty. We will be accused of crime of preventing a personal liberty of a person by putting him in a imprisonment. There are many cases who have not got the advantage of a proper assistance and they remain in jail. Now the legal system, we have got constitutional amendment, Article 39, where the legal service authority is there, legal assistance is there, professional assistance is given. But with this sufficient, and whether courts now burdened with criminal cases, whether it's sufficient, whether it could need for now increasing the number of criminal courts, because we have got so many laws, so many special laws, so many offenses, different kinds of offenses, and every case needs urgent hearing. Now we have got a political cases, different courts. We have got a juvenile cases. We have got a POSCO cases. Different courts, special laws are made, special courts are made. Now at the same time, unless we achieve the speedy trial, unless we achieve that the trial is completed at a particular time, it may not justify the criminal justice system, and it may defeat the purpose for which the criminal justice system has been there since ancient time. And these are my few observations on the criminal justice system, which I found that there are some areas where there is a need for reforms. And today's trend of criminal law, there is a vast difference. The traditional way of committing crimes and today, it is not a case of theft, murder, or anything. Those were the commonly which we are used to. Now today the crimes are different. Cyber crimes are there. There are various crimes based on information technology. Every day there is a person losing a money from the bank. There is every day frauds are committed. There is every day, because we have so much access to the information. Now the people are falling trapped to the attractive offers are made. So many things, but these people cannot be caught because the international problem is there. The information technology, crimes based on the information technology, because the accused will be in some other country, he offers something, he collects the money, and ultimately the person, the victim, will be at some places who has no access to any this thing. There is no procedure how the crime to be registered against for a national who is in the other country. So there has to be proper treaty to meet the today's challenge of such crimes. So many things are there we are facing, and today it is a changing world. It is a changing world. It is a changing complete. And in these circumstances, now the men in authority and person in holding the offices must think of the reforms and must think that in the light of the cyber crimes, in the light of the crimes based on the information technology, and to get a justice for them, how best we can equip the investigation agency, because many times we may not be knowing the ways in which the crime is committed, because the crimes are committed based on such using the technology. Which technology we are not familiar, we may not be in position to appreciate. So the knowledge of such information is also equally important. Proper training for the judicial officer, proper training for the prosecution, and expertise, investigation. All these things need for it. There is a need for change. This is my personal view. And since we have a time for interaction also, based on if the law students are on the line, and if there are any suggestion and questions which we can interact and evolve any solution for these certain difficulties which we are facing. Now, reformation is something which is one area. Now the jail authorities have taken that by educating, by giving the occasion, by giving some kind of training to the accused also. That is one kind of reformation of the accused. Similarly, the criminal justice system starts from home also, because when someone commits a wrong, there is the father will blame, or there will be some pat on his back and something, otherwise he will say. These are the reformative aid to understand why the deterrent punishments are given, is to create a fear in the mind of other person who is likely to commit. Anyway, these are my personal views on these aspects. And if any suggestions on the interaction is necessary, I will be very happy to respond if possible. Thank you.
Yes, Ms. Anuj
Hello.
Chengappa.
Good
Hello.
evening, sir. Good
Yes,
evening,
good
sir. This is Anu Chengappa, sir. Thank you very much for that very enlightening and articulate lecture.
Yes.
So I have just one, especially given the under trial problem, and as you rightly pointed out, our jails are overflowing with under trials.
Yes, yes.
Plea
Now the plea
bargaining,
bargain. Yes.
yes.
Yes, madam.
Whether it is a solution, and whether that is the way forward, especially when it comes to the under trial problem, and to what extent in the Indian context we can use it as an effective tool, sir.
Yes. Now the plea bargain is very prevalent in America and Western countries. Plea bargain is, we have borrowed it. Now plea bargain is where accused admits his guilt, bargains for his punishment. Now we have no tendency, particularly here in India, every accused defends himself that he is not guilty. Very difficult to get an accused to say that he has committed a crime. Now, plea bargain requires, first and foremost, is that he admits his guilt and bargains for his punishment. Now, the bargain is what extent the punishment can be reduced. In American system, they have got much more than crimes much more than India. Each police station registers lakhs of cases, but the trial would be very few. The trial will be for very few such cases. Now in India, though we have an amendment to the procedural law and plea bargain is prescribed, but nevertheless, very few cases are coming under the plea bargain. The people mindset has to change, and they must come forward that if they have committed a crime, they must admit and beg for their lesser punishment. That is the one way. Yes, madam.
So if I can just add an annex question to
Yes.
that. I want to draw a parallel to mediation. Initially, when mediation was introduced, there
Yes.
was a lot of resistance. In fact, the legal fraternity itself was not too happy with it because they felt it would adversely impact the profession of the lawyers and stuff like that. But today, that is something that all of us are happy that we have, and it's phenomenally helping in sorting out cases. So I was just wondering if the initiative comes from members of the bench and the bar to
Yes.
actually put forth this concept of plea bargaining to remove some of the misconceptions. It could probably go a long way in.
Yes, definitely. This is one way of definitely it can be appreciated. But the question is now in the Indian society, particularly the crimes which are committed, we have a very few cases which end up in conviction. There is a misconception in the accused, or they may be right also. They think that the conviction itself is not possible. Why should I go for plea bargain? Now that is why beginning I said the percentage of conviction are very few, because the prosecution, faulty prosecution, and reasonable doubts are there. These are all the questions which add to the accused acquittal. So in these circumstances, conviction rate is very less. Now when the accused and defending lawyer feels that no necessity to go for plea bargaining when you will be set free. When you are set free, why should he the approach for the plea bargaining? This is the rate where conviction rate needs to be increased, not by just to increase the number of conviction, but quality of investigation, quality of the prosecution, that is the base of the conviction, which has to be improved, because the investigation agency takes so much of time to investigate and file a charge sheet. Even if they file a charge sheet, there will be faulty witnesses which have to be examined, with evidence which need to be collected, they don't collect it. End of the day, for lack of evidence, ultimately it leads to acquittal. Now, if this happens, now to go for plea bargaining, very few people will come. Even if we make an effort also, all of us think that we will they give importance for the plea bargain. But mindset has to change. The accused mindset has to change. Yes, madam. Yes, anybody?
Yes, my lord.
Yes.
Lordship, the stigma that's going to be attached, that is not removed so far in the plea bargaining. There are some offences which leads to moral turpitude and it may affect the further progress of basically the criminal jurisprudence based on the reformation theory.
Yes.
But unless that stigma attached doesn't go, nobody would come forward for plea bargaining.
Plea bargain definition itself is you are bargaining with the punishment.
Yes.
If you are bargaining with the punishment, punishment presupposes the commission of a crime.
Yes, yes.
And if it is a commission of crime, the question of stigma, but if the crime itself is a stigma on a person, you cannot say that he has not committed a crime and we will punish him. Can it be possible?
No, that's true, my lord. That's true. But what in India, what is happening in other countries compared to other countries?
Yes.
The stigma invariably the stigma will not come in the way because the reformation theory would. Otherwise, once the crime is admitted and his name will be always there in the police station, and whatever other crimes takes place in the village, he will be the first person to be interrogated or the troubled in the present scenario of the police system that we have got. He will be the first person to be interrogated or troubled.
I likely to refer with that. See, it is not a stigma. Once if he is convicted and he is released, he is acquitted, he is released from if he completes the sentence, this is not treated as stigma. He is as good citizen as any other citizen. And he has every right to live in the society. Now rehabilitation programs are, even the jail authorities are providing the training for whatever training he is possible. He may become a carpenter. For example, you take Sanjay Dutt's case. Yes. Sanjay Gandhi, when he was imprisoned, he underwent a training for carpentry. He did some carpentry work and he came out with carpentry. Though it may not be necessary, but for future.
That's true. In the records, it is said now it is a correction center now. Even the nomenclature has been changed.
Yes,
that of jail as a correction center.
Yes.
But the society as such, how they are treated, it is
it is not what the overnight change is possible. Society is also changing. If you look at if we go back 30, 40 years, which I have seen, anyone who has committed theft, they was looked down by the entire town, entire village. He's a thief. He's a thief. He's called. But today it is not there.
Yes.
Today, even if the person is convicted and undergoes the punishment, you have seen so many persons, and particularly, I do not want to name, those persons are in realm of affairs.
It's true. That is the society decisive factor is that
society changing.
Those class of people are they are treated differently, and other people, poorest of the poor, I mean, in the villages, these takes place. They are treated in a different way.
Maybe there, but it also depends on the accused. If he's a professional offender, frequent offender, there is possibility that people will look at him. That is why there is a provision also in the criminal justice procedure. Frequent offender, what punishment? He will get a more severe punishment.
Yes.
Yes.
Yes. Namaste, sir. This is Professor Suresh Nalgodar, Principal, University Law College.
Yes, Suresh.
Thank you very much, sir, for your very comprehensive and valuable address on the criminal justice system. And just I would like to know from you that whenever we file a complaint in the official capacity against any persons who commit offenses and all, we only need to appear before the court to give the evidence. So can the successor officer in that position be allowed to give the evidence, sir? Otherwise, many officers, because they are required to, whenever they are transferred to other places, they are required to go to the court to give the evidence, and many a time evidences will not be recorded. It is, and as a result of which, many officers will not take any interest to initiate criminal action against the offenders. This I would like to
Correct,
know.
Suresh.
your
You're
opinion. Yes, sir.
the two types of the appearance. There are two types of appearance in criminal cases.
Sir.
See, if you are summoned to appear before the court with a document, it is not the person involved,
Sir.
but a person who registers the crime or person who reports the crime,
Sir.
who has the personal knowledge. Now, question arises particularly in the criminal justice system, because we need a perfect evidence. It is the knowledge of a person is important. That is why those persons who had the personal knowledge, they have to come and depose. Suppose if you are the person who has the complete knowledge of the crime, how it is committed in your office, and it cannot be spoken by your successor because he has no knowledge. He will get the knowledge only through you. Now, becomes a hearsay evidence. That is the required. But if the question is to produce a document, for example, misappropriation of accounts are there. Any successor can produce the accounts. Ultimately, it is a document. But personal knowledge is important. In evidence, what is important is who is giving evidence. Suppose any successor comes and says that my predecessor's time there was a theft and he had seen the theft. At the end, he is the accused. He had told me. Can it be accepted?
Okay.
These are the difficulties which will be faced by the trial, and it becomes weak case.
Yes, sir. But particularly it is discouraging the officers to initiate action, sir. For example, when I was in Kadaganchi University, some person was taking out the soil and all. So I lodged a complaint, and this is the third or fourth time I have gone to give evidence, but for one or the other reason, the evidence could not be recorded. And every time it is causing a lot of
These
inconvenience.
difficulties, day for yesterday is the similar thing. One of our subordinate officer in one of the assignment where he lodged a complaint because he has to lodge the complaint in 2012. And he had gone at least a dozen of times to go to the court and for giving a statement. For some reason, it is not happening. That is why I said speedy trial is a motto. Must speedy trial, because within time frame, unless you get a deliver, if you don't deliver judgment, you don't complete the trial, then it becomes very difficult. Then it leads to acquittal. That is the reason we need to change the system, because we have got such a vast procedure law. We have and there is a number of chances for the defense lawyer to get it prolonged. So we need to see those procedure laws are changed.
So at least 1 or 2 times it's okay, sir. Otherwise, leaving all our work here and to go.
You are right. For the officers, when the officer is before the court, his evidence must be recorded.
Yes, sir. Yes, sir.
That should be there.
Something like that should be made it mandatory on the part of the court, and they should take it on priority, sir.
Yes, I'll tell you. In England, they give the date and the time.
Correct, sir.
An Indian origin doctor who is there for last more than 40 years, who was my client, he had come to India to depose, and he could not give the evidence, and he made an issue of that. He said, how many times I can come here?
Correct.
When I come, they must record. Because of pressure of work, it did not happen. Correct. The procedure in England is, moment the time is given to the doctor to come before the court on particular time, it will be recorded on that day. There is no question of any adjournment. The evidence would be recorded. Now, system has to be brought that on particular day, witnesses have to be examined. It must be examined. On particular day, prosecution has to address. It must be. Now, you find the reforms in the arbitration. Recent, now the laws have changed. Within the framework, you need to deliver you need to complete it. So this type of, for example, recently I attended Singapore International Arbitration Conference, where they have got time frame. Now, you believe it or not, 9 hours for writing an award. They want it because the international arbitration takes place. They don't want to spend the time on a small issue. Today, if you have fixed the evidence is to continuously completed within 2 days. Similarly, arguments, 2 days must 2 days. And award must be, a particular day, award has to come. Now, this is where we need a reforms. And particularly in criminal justice system, it is must, because More the time, there is a more, see, witnesses will not remember, witnesses version will differ. So many reasons will come. We need not even openly say witness will be one more.
Correct.
The very purpose of prosecution will be defeated.
Okay. No, somehow something like that should be done even in India.
No.
And
the other
yes,
countries, because they have got that system. Now
yes,
we have adopted such a system, English law only, but they have changed, we have not changed.
yeah, they have reformed. Yes, sir.
We have not changed.
Sir, one more small thing, sir. Whether in such cases evidence can be recorded wherever personal evidence is to be given by the officer on online, and documents be submitted
What
by
about
the
the
successor officer.
cross-examination? Cross-examination, and you cannot be examined.
Yes, sir.
With the assistance of an prosecutor, assistance of an advocate.
Examination online, sir. Online, they can be asked to appear. And
Civil law, you can be examined online, but the cross-examination has to happen.
Okay. No, even cross-examination also can be done online, no, sir.
See, then whether the defense lawyer or the prosecutor has to come to your place.
No, sir. The system should be
No,
developed in
that
the
is possible.
court.
Yes, you are right.
From there
Online
only
you can
they
do
can
it.
cross-examine and also take the evidence.
What is the evidence? The oral evidence is what is in your knowledge. Suppose if you are deposing and you are assisted by an expert lawyer to say that this is, this is this, he gives in writing that you say this. That becomes that will not be evidence which can be relied.
Yes.
See, this was the erstwhile system, but in criminal you have to give proper evidence.
Sir, my submission is that instead of the complainant being physically present in the court, let him appear online. Let him give the evidence online and be recorded, and he also be cross-examined online.
He
Can
can
such
be
a system be
cross-examined.
developed in India, sir?
See, normally when the witness is examined, he is not assisted by his counsel.
Okay.
He gave only to ensure that he gets he speaks on his personal knowledge, not on somebody's information. Now the cross-examination objective is to elicit the truth. He will put in such questions. And if the questions are not impossible, it is not possible for the witness to answer and someone assist him. Now, possibility of defeating, maybe you are right, it can be done if the witness and if the prosecution and the defense takes the responsibility.
Yes, sir. As the hearings are done in high courts and Supreme Court
Now,
online, sir,
arguments are
system
even,
can
we
be
have
established.
recorded evidence. In arbitration,
Yes,
we record evidence because
Yes, sir.
one witness was in England, we recorded evidence.
Yeah.
For civil law, it is no difficulty. If the other side agrees, it can be done.
Okay, sir. Okay. Thank you, sir. Thank you very
Okay.
much.
Yes.
ಎಲ್ಲ ಪ್ರಶ್ನೆಗಳು ಮುಗಿದಂಗೆ ಕಾಣಿಸುತ್ತೆ.
ಮಾತೋಳಿ ಸರ್ ರೇಸ್ ಮಾಡ್ದಂಗಿದೆ.
I first take this privilege, sir, to welcome and thank Justice S. Abdul Nazir, who is also participating in this lecture series today.
Very good.
We are all very overwhelmed by your presence here, sir. I welcome on behalf of the Vijnaneshwara Pratisthana Trust and all other members here, participants here today. So there is no other.
Matholi sir has raised his hand, I think.
I would like for the law students to come forward and let us know how they understand. Do they have queries?
Sir, namaste sir.
Namaste.
ಸರ್ ನಾನು ಫಸ್ಟ್ ಇಯರ್ ಲಾ ಸ್ಟೂಡೆಂಟ್ ಸಿದ್ಧಾರ್ಥ ಕಾನೂನು ಮಹಾವಿದ್ಯಾಲಯ ಗುಲ್ಬರ್ಗದಿಂದ ಮಾತಾಡೋದು ಸರ್. ನನ್ನ ಹೆಸರು ಪರಮೇಶ್ ಅಂತ ಸರ್.
ಹೇಳಿ
ಸರ್, ನಾನು ಒಬ್ಬ ನಮ್ಮ ಸೀರಿಯನ್ ಹತ್ರ ಒಂದು ಕೇಸ್ ನೋಡಿದೀನಿ ಸರ್. PC ಆಕ್ಟ್ ಅಲ್ಲಿ ಅವರಿಗೆ ಕೇಸ್ ಬುಕ್ ಆಗಿದೆ ಸರ್ ಒಬ್ಬ ಕ್ಲೈಂಟ್ ಮೇಲೆ ಸರ್. ಸೊ ಆ ವಿಚಾರಣೆ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ನಡೀತಾ ಇದೆ ಸರ್, ಮತ್ತೆ ಲೋಕಾಯುಕ್ತ ಬೆಂಗಳೂರಲ್ಲಿ ಕೂಡ ಅದೇ ಸೇಮ್ ವಿಚಾರಣೆ ನಡೀತಾ ಇದೆ ಸರ್. ಸೊ ಒಂದು ಅಫೆನ್ಸ್ಗೆ 2 ಕಡೆ ವಿಚಾರಣೆ ಸೂಕ್ತ ಸರ್. ಅದರಿಂದ
ಇಲ್ಲ,
ಏನು
ನಡೆಯೋದಿಲ್ಲ. ಒಂದೇ ಕ್ರೈಮ್ಗೆ 2 ಟ್ರಯಲ್ ನಡೆಯೋದಿಲ್ಲ. ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನಲಿ ಪ್ರೊಹಿಬಿಟೆಡ್.
ಹೌದು ಸರ್. ಈಗ ಅದು ಅಫೆನ್ಸ್ ಅದು PC ಆಕ್ಟ್ ಅಲ್ಲಿ
ಬೇರೆ ಇರಬೇಕು. ಬೇರೆ ಅಫೆನ್ಸ್ ಇದ್ರೆ ಬೇರೆ ಟ್ರಯಲ್ ನಡೀತಿದೆ. ಒಂದೇ ಟ್ರಯಲ್ ಒಂದೇ ಅಫೆನ್ಸ್ 2 ಕಡೆ ನಡೆಯಲ್ಲ.
ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಕೂಡ ನಡೀತಾ ಇದೆ ಸರ್. ಆಮೇಲೆ ಇಲಾಖೆ ವಿಚಾರಣೆ ಅಂತ ಬೆಂಗಳೂರಲ್ಲಿ ಕೂಡ ನಡೀತಾ
ಇಲಾಖೆ
ಇದೆ.
ವಿಷಯ ಅದು ಬೇರೆ, ಅದು ಎನ್ಕ್ವೈರಿ. ಅದು ದಟ್ ಹ್ಯಾಸ್ ನಥಿಂಗ್ ಟು ಡೂ ವಿತ್ ದಿ ಕ್ರೈಮ್. ಕ್ರೈಮ್ ಇಸ್ ಡಿಫರೆಂಟ್. ಇಟ್ ಇಸ್ ಈವನ್ ಸಿವಿಲ್ ಕೇಸು ನಡಿಬಹುದು. ಅದಕ್ಕೇನು ಇದಿಲ್ಲ. ಸಿವಿಲ್ ಕೇಸ್ ಈಗ ಫಾರ್ ಎಕ್ಸಾಂಪಲ್ ಒಂದು ಸಿಂಪಲ್ ಎಕ್ಸಾಂಪಲ್ ಕೊಡೋದಾದ್ರೆ, ಈಗ ಚೀಟಿಂಗ್ ಕೇಸ್ ಇರುತ್ತೆ, ಅದರಲ್ಲಿ ಮನಿ ಇನ್ವಾಲ್ವ್ ಇರುತ್ತೆ, ಅಥವಾ ಆ ಮನಿ ರಿಕವರಿಗೆ ಅವನು ಸೂಟ್ ಹಾಕೊಂಡಿರ್ತಾನೆ, ಇಲ್ಲಿ ಒಂದು ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ಹಾಕೋತಾನೆ. ಇಫ್ ಯು ಶೋಸ್ ದಟ್ ದೇರ್ ಇಸ್ ಎ ಕ್ರಿಮಿನಲ್ ಅಫೆನ್ಸ್ ಅಂದ್ರೆ 420 or 409 ಏನದು ಯಾವ್ದಾದ್ರು, ಅದು ನಡಿಬಹುದು, ಇದು ನಡಿಬಹುದು. ಅದ್ರದ್ದೇ ಇದನ್ನೇ ಬೇರೆ. Scope of civil trial is different from criminal. Criminal is aimed to punish him.
Okay, sir. Okay, sir.
Okay.
Thank you, sir.
Okay. Anybody?
Sir, participants may ask questions with not relating to any pending matters, please. That will embarrass the honorable speaker also.
That's right. ಮತ್ತೆ ಯಾರಿಗಾದರೂ ಏನಾದರೂ ಕೇಳಬೇಕಾ ಅಥವಾ ಏನಾದರೂ? See, we must use this opportunity because such an arrangement is made, and it
Good evening, my lord.
Yes.
Good evening, my lord. I'm Shanant from Haveri.
ಹೇಳಿ.
My lord, plea bargaining ಅಲ್ಲಿ ಸೋಶಿಯೋ ಎಕನಾಮಿಕ್ ಅಫೆನ್ಸಸ್ ಎಲ್ಲ ಪ್ಲೀ ಬಾರ್ಗೇನಿಂಗ್ ಮಾಡ್ಕೋಬಹುದಾ?
ಏನಂದ್ರಿ?
ಇಡಿ ಸೋಶಿಯೋ ಎಕನಾಮಿಕ್ ಅಫೆನ್ಸಸ್ ಎಲ್ಲ ಇರ್ತವಲ್ಲ, ಇಡಿ ಅದು ಇದು ಹಣ ಅಲ್ಲಿ ಜಪ್ತಿ ಆಯ್ತು, ಈ ತರದ ಅಫೆನ್ಸ್ ಗಳನ್ನೆಲ್ಲ ಪ್ಲೀ ಬಾರ್ಗೇನಿಂಗ್ ಮಾಡ್ಕೋಬಹುದಾ ಅಂತ.
ಪ್ಲೀ ಬಾರ್ಗೇನಿಂಗ್ಗೆ ಪರ್ಟಿಕ್ಯುಲರ್ ಅಫೆನ್ಸಸ್ ಅಷ್ಟೇ ಇನ್ಕ್ಲೂಡ್ ಆಗಿದೆ. ಓನ್ಲಿ ದೋಸ್ ಅಫೆನ್ಸಸ್ ಫಾರ್ ವಿಚ್ ಯು ಕ್ಯಾನ್ ಹ್ಯಾವ್ ಎ ಪ್ಲೀ ಬಾರ್ಗೇನಿಂಗ್. ಕೆಲವು ಕೇಸಿಗೆ ಪ್ಲೀ ಬಾರ್ಗೇನಿಂಗ್ ಇಲ್ಲ. ದೇರ್ ಇಸ್ ನೋ ಪ್ರಾವಿಷನ್ ಫಾರ್ ಪ್ಲೀ ಬಾರ್ಗೇನಿಂಗ್. ಸರ್ಟನ್ ಕೇಸಸ್ ಎಲ್ಲಿ ಅದು ಶೆಡ್ಯೂಲ್ ನಲ್ಲಿ ಬರುತ್ತೆ ಅಂತದ್ರಲ್ಲಿ ನೀವು ಪ್ಲೀ ಬಾರ್ಗೇನ್ ಮಾಡಬಹುದು. ಬಟ್ ಅಫೆನ್ಸಸ್ ವಿಚ್ ಆರ್ ಎಕ್ಸ್ಕ್ಲೂಡೆಡ್ ಫ್ರಮ್ ಪ್ಲೀ ಬಾರ್ಗೇನಿಂಗ್ ಅದನ್ನ ಇನ್ಕ್ಲೂಡ್ ಮಾಡಕ್ಕಾಗಲ್ಲ. ಅದಕ್ಕೆ ಲಿಸ್ಟ್ ಇದೆ ಅದು.
Thank you, my lord.
Okay.
Sir, is plea bargaining constitutional?
Plea bargain is a law now made by it, as long as law is on the statute book and it is deemed to be valid, deemed to be constitutional. Nobody has questioned it. If it is questioned and if the court says that it is unconstitutional, it becomes unconstitutional. As long as the law is there on the statute, is there, it is valid.
Okay, thank you, sir.
Okay.
Sir, I would like to ask a question. In criminal matters, as a counsel appearing for the accused, I come up with cases where accused's presence is required on every date of hearing, though there will be absolutely no roles. In a particular case, if there are 10 accused and 1 or 2 accused have been served, others have not been served, there is no fruitful purpose which would be served by asking the accused to be present on every date. Why this?
That's right. Yes, sir. You have a valid point. In fact, there is also debate is going whether the accused should need to be kept present every date of hearing, or his presence can be ensured on the date when the court requires. This debate is going on, but still no solution is found. And particularly when the other accused are not served and some of the accused have to come and stand till the service is made. Years together it will go. More than a punishment, it is humiliation also. You're right. This is the valid point, and the legislation has to think on this.
Apart from that, in fact, as advocates, we keep filing all applications with false reasons. This is what is happening also.
Yes, Dheeraj.
Sir, apart from this, what as advocates, in order to get the exemption for that particular day, we tend to give false reasons as well. So at least these things could be curtailed.
Correct. False. As long as the court accepts it, you cannot say it is false. Only you may be knowing and the other may be. Court accepts it. For example, doctor certificate, court can't disbelieve it if the government doctor or authority who can give a certificate and it has to be accepted by the court have to accept it. And where there is a possibility of granting exemption, they grant the exemption. Yes?
There are few more participants who want to ask the question.
Yes.
Mr. Abdul Rao.
Yes.
Mr. Abdul Rao.
Yes.
Mr. Mohan Rathod.
Call next.
Yes, sir. I'm
No more questions. Okay.
Okay.
Dr. Matul.
Good evening, my lord.
Good evening.
Sir, just in continuation of what Dr. Suresh Nadgowder discussed with you, as
Yes.
part of witness protection scheme,
Yes.
can we not have these witness examination centers so as to accommodate these official witnesses if they are staying in other places?
Yes, definitely. We
Yes.
see with protection of a witness, protection of evidence, securing the evidence is more important because depending upon the nature of crime, their life will be in danger. There will be some kind of threat also. It
Yes,
needs
sir.
to be protected, and this is going on for a long time. The protection of witnesses and their identity, particularly, it is in some cases, offenses. Some offenses there is a protection, but for all the offenses where the witness protection and their security has to be protected, because tomorrow if he gives, that is why maybe it is my personal perception that most of the witnesses will not come before the court. Most of the people who have seen the crimes will not come before the court or the police to depose, having regard to the threat to their life or having regard to the possibility of future threat. They may not come. Protection is there, ensuring their life security. Possibility is there because their identity has to be kept in.
Yes, sir. Yes, sir. Yes, sir. Thank you, sir. Thank you.
Yes. Yes. Yes.
Myself, Abdul Rao, advocate from Jamshedpur.
Yes.
So I need to know something about split up of charges, Your Lord. When there is a pending case filed in the ICC before the Honorable Court, and due to the non-availability of one of the accused among 5-6 accused, the charges is split up. So after proceeding with the remaining accused in one part of the charges, 3-4 witnesses were examined. After that, another accused who was not available was brought before the Honorable Court. Can at this stage the split up charges can be clubbed with the present case, which is ongoing recording the witnesses?
You mean to say that there is a split of charge sheet?
Yes, Your Honor. It's less manner.
Split of charge sheet?
Split of charge.
No, the charge sheet, they may file additional charge sheet. There is nothing like this.
It is split charge sheet before the Honorable Court.
See, some of the accused, for example, the absconding accused who are not. Yes, charge sheet is filed for the accused who have been arrested and investigation is completed. Those accused who were absconding and arrested, thereafter the investigation is made. Additional charge sheet with the court permission they can file.
No, my lord. Already arrested and enlarged on bail by the Honorable Court. After that, one of the accused was absconding.
After the charge sheet?
Yes, my lord.
After the charge sheet, if is absconding means then again a warrant has to be issued and he has to be arrested. That's the procedure. You know it also.
During that time, the charge sheet was split up by the Honorable Court itself and proceeded with the remaining accused who are available for the trial.
I did not catch it. Can you make it once again? What do you want to?
After enlarging all accused,
Yes. You mean to say that unless all accused are arrested and the investigation is complete and charge sheet is filed, then the trial has to be stopped then.
Yes, my lord.
What happens to the accused who have been arrested years back and there is investigation is completed and there is no possibility of getting the other accused?
Yes, my lord.
Then the difficulty would be prosecution also, investigation also, and the burden on the investigation agency to keep the charge sheet, because there is a limitation for filing charge sheet also.
Yes, my lord.
Yes,
So,
charge sheet has to be filed.
yes, my lord. So, they
Thank you,
kept
sir.
the
Thank you.
because of the non-available one of the accused, which is
Okay.
called.
Okay.
Thank you.
Anybody else, if we have time?
Sir, the time is around 7:07. We have the other presidential
Okay.
speaker also to make his remarks, presidential remarks by the.
Okay, thank you. Yes, we will conclude it.
Yes, sir. So, ಇಂದು ವಿಷಯದ ಕುರಿತು ವಿಸ್ತೃತ ಉಪನ್ಯಾಸ ನೀಡಿದ ವಿಶ್ರಾಂತ ನ್ಯಾಯಮೂರ್ತಿಗಳಾದ ಹಾಗೂ ವಿಶ್ರಾಂತ ಉಪಲೋಕಾಯುಕ್ತರಾದ ಶ್ರೀ ಸುಭಾಷ್ ಬಿ ಆದಿ ಅವರಿಗೆ ಧನ್ಯವಾದಗಳು. ಇಂದಿನ ಕಾರ್ಯಕ್ರಮದ ಅಧ್ಯಕ್ಷ ಸ್ಥಾನ ಅಲಂಕರಿಸಿದ ಅಸ್ಸಾಂನ ಕುಮಾರ್ ಭಾಸ್ಕರ್ ವರ್ಮಾ ಸಂಸ್ಕೃತ ಮತ್ತು ಪುರಾತನ ಅಧ್ಯಯನ ವಿಶ್ವವಿದ್ಯಾಲಯದ ಮಾನ್ಯ ಕುಲಪತಿಗಳು, ಕಲಬುರಗಿಯವರೇ ಆದ ಪ್ರೊಫೆಸರ್ ಪ್ರಹ್ಲಾದ್ ಆರ್ ಜೋಶಿ ಅವರು ತಮ್ಮ ಅಧ್ಯಕ್ಷೀಯ ಭಾಷಣ ನೀಡಬೇಕೆಂದು ವಿನಂತಿಸುತ್ತೇನೆ.
ಜಯತಿ ಪರಾಶರ ಸೂನು ಸತ್ಯವತಿ ಹೃದಯ ನಂದನೋ ವ್ಯಾಸಃ ಯಸ್ಯ ಹಾಸ್ಯಕಮಲ ಗಲಿತಂ ವಾಂಗ್ಮಯಂ ಅಮೃತಂ ಜಗತ್ಪಿಬತಿ. ನಮಸ್ಸಭಾಯೇ, ಎಲ್ಲರಿಗೂ ನಮಸ್ಕಾರ. ಈ ಕಾರ್ಯಕ್ರಮದಲ್ಲಿ ಭಾಗವಹಿಸಲು ಅವಕಾಶ ಮಾಡಿಕೊಟ್ಟಿದ್ದಕ್ಕಾಗಿ ತುಂಬಾ ಧನ್ಯವಾದಗಳು. ಈ ಕಾರ್ಯಕ್ರಮಕ್ಕೂ ಮತ್ತು ನನಗೂ ಸಂಬಂಧ ಇರೋದೇನೆಂದ್ರೆ, ರಾಮ ಜೋಯಿಸರು ಅವರು ಏನು ಈ ಮಿತಾಕ್ಷರ ಎಂಬ ಗ್ರಂಥದ ಒಂದು ವಿಶೇಷ ಅಧ್ಯಯನ ಮಾಡಿದನ್ನ ಪ್ರಕಾಶನ ಮಾಡಿದ್ರು. ಆ ಗ್ರಂಥದ ರಚನೆ ಮಾಡಿದಂಥ ವಿಜ್ಞಾನೇಶ್ವರ ಭಿಕ್ಷು ಅವರು, ಅವರ ಸ್ಥಾನ ಮರ್ತೂರು ಮತ್ತು ಗುಲ್ಬರ್ಗ ಕೇವಲ 15 ಕಿಲೋಮೀಟರ್ ದೂರದಲ್ಲಿದೆ. ಸೊ ಈ ಒಂದು ಸಂಬಂಧದಿಂದ ಈ ಕಾರ್ಯಕ್ರಮಕ್ಕೆ ನಾನು ಭಾಗವಹಿಸಲಿಕ್ಕೆ ಅರ್ಹ ಅಂತ ಅಂದ್ಕೊಂಡಿದ್ದೀನಿ. ಮೊಟ್ಟ ಮೊದಲ ಹೇಳ್ಬೇಕಂದ್ರೆ, ನ್ಯಾಯಾಲಯದಲ್ಲಿ ನ್ಯಾಯಾಧೀಶರು, ನ್ಯಾಯಮೂರ್ತಿಗಳು ಅವರು ಮಾತಾಡಿದ ಮೇಲೆ ಬೇರೆ ಯಾರು ಮಾತಾಡಬಾರ್ದು. ಸಾಮಾನ್ಯವಾಗಿ ಯಾರು ಮಾತಾಡೋದಿಲ್ಲ. ಆದ್ರೆ ಇಲ್ಲಿ ನಾವು ಒಂದು ಅಧ್ಯಕ್ಷೀಯ ಸ್ಥಾನ ಕೊಟ್ಟದ್ದಕ್ಕಾಗಿ ಒಂದು ಕೆಲವು ಮಾತು ಹೇಳಬೇಕು ಅಂತ ಬಯಸ್ತಾ ಇದ್ದೀನಿ. ನಾನು ಸಂಸ್ಕೃತ ಬ್ಯಾಕ್ಗ್ರೌಂಡು, ಗುಲ್ಬರ್ಗಾದಲ್ಲಿ ಓದಿರೋದು. ಈಗ ಇವತ್ತು ನಾಳೆ ಈ ಹೈಕೋರ್ಟ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಎಲ್ಲ ಲೈವ್ ಟೆಲಿಕಾಸ್ಟ್ ಆಗ್ತಾ ಇರ್ತದೆ. ಬೆಳಿಗ್ಗೆ 9 ಗಂಟೆಗೆ ನಾವು ಆಫೀಸ್ ಹೋಗುವಾಗ ಗೌಹಾತಿ ಯೂನಿವರ್ಸಿಟಿಯಲ್ಲಿ ಒಂದು ಸುಮಾರು 15 ಇದಿದೆ ಕೋರ್ಟ್ ಬೇರೆ ಬೇರೆ. ಸೊ ಎಲ್ಲದಕ್ಕೂ ಸಬ್ಸ್ಕ್ರೈಬ್ ಮಾಡಿದ್ದೀನಿ. ಆ 1 ಗಂಟೆ ಅವಧಿಯಲ್ಲಿ ಪ್ರತಿದಿನ ನಾನು ಆ ಕೋರ್ಟ್ ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ನಾನು ನೋಡ್ತಾ ಇರ್ತೀನಿ. ವಿಶೇಷವಾಗಿ ನಾವು ಸಿನಿಮಾದಲ್ಲಿ ನೋಡೋದು ಒಂಥರ ಬೇರೆನೆ ಇರ್ತದೆ, ಇಲ್ಲಿ ಆಕ್ಚುಲ್ ನಡೆಯೋದು ಕೂಡ ಬೇರೆನೆ. ಸೊ ಹೀಗಾಗಿ ಯಾವ ತರ ನಡೀತದೆ, ಯಾವ ತರ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತಾರೆ, ಇವೆಲ್ಲ ಕುತೂಹಲದಿಂದ ನಾವು ಕೇಳ್ತಾ ಇರ್ತೀವಿ. ವಸ್ತುತಃ ವಿಷಯದ ಬಗ್ಗೆ ನಮ್ಗೆ ಅಷ್ಟು ಗಹನ ಅಧ್ಯಯನ ಮಾಡಿಲ್ಲ ನಾನು, ಈ ಕ್ರಿಮಿನಲ್ ಲಾಸು ಅದು ಇದು. ಆದ್ರೆ ಕೆಲವು ಅನುಭವಗಳು, ನನ್ನ ದೃಷ್ಟಿಯಲ್ಲಿ ಕೆಲವು ಅನುಭವಗಳು ಏನಿದೆ ಅದನ್ನ ಮಾತ್ರ ತಮ್ಮ ಹತ್ರ ಹಂಚ್ಕೊಳ್ತಾ ಇದ್ದೀನಿ. ಇವಾಗ RTI ಯಾವುದು 2005ರಲ್ಲಿ ಅನ್ಕೋತೀನಿ, 2005ರಲ್ಲಿ RTI ಬಂದ್ಮೇಲೆ ಅದರ ಉಪಯೋಗಕ್ಕಿಂತ ಹೆಚ್ಚು ದುರುಪಯೋಗನೇ ಆಗ್ತಾ ಇದೆ ಅಂತ ನನ್ನ ಅನಿಸಿಕೆ. ತಪ್ಪಿರ್ಬೋದು, ತಾವೆಲ್ಲ ಕ್ಷಮಿಸಬೇಕು. ಯಾಕಂದ್ರೆ ನಾನು ಆಗಿರುವಾಗ ನಾನು ಸುಮಾರು RTIಗಳು ಬರ್ತಾ ಇರ್ತದೆ ರೆಗ್ಯುಲರ್ ಆಗಿ. ಆಶ್ಚರ್ಯ ಏನು ಅಂದ್ರೆ, ಆ ವ್ಯಕ್ತಿ ಕೇಳಿದ ವ್ಯಕ್ತಿಗೆ ಆ ಬೇಕಾಗಿರೋ ಇನ್ಫಾರ್ಮೇಶನ್ ಒಂದು ಅವಶ್ಯಕತೆ ಇರೋದೇ ಇಲ್ಲ. ಆದ್ರೂ ಅವನೊಂದು RTI ಹಾಕ್ಬಿಡ್ತಾನೆ, ಒಂದು 10 ರೂಪಾಯಿ ಯಾವುದೋ ಪೇ ಆರ್ಡರ್ ಯಾವುದೋ. ಹಾಗಾಗಿ ಅವನಿಗೆ ಆ ಇನ್ಫಾರ್ಮೇಶನ್ ಅವಶ್ಯಕತೆನೇ ಇಲ್ಲ, ಆದ್ರೂ ಅವನು ಆ ಇನ್ಫಾರ್ಮೇಶನ್ ಕೇಳ್ತಾ ಇರ್ತಾನೆ. ಸೊ ಇದ್ರ ಬಗ್ಗೆ ಏನಾದ್ರೂ ನಾವು ವಿಶೇಷವಾಗಿ ವಿಚಾರ ಮಾಡಬೇಕು ಅಂತ ನನಗನ್ಸುತ್ತೆ. ಆ ವ್ಯಕ್ತಿಯ ಇನ್ಫಾರ್ಮೇಶನ್ ಕೇಳೋ ಉದ್ದೇಶ ಏನು, ಯಾವುದಕ್ಕಾಗಿ ಆ ಇನ್ಫಾರ್ಮೇಶನ್ ಬೇಕಾಗಿದೆ, ಅದೇನು ಸಾರ್ವಜನಿಕ ಹಿತಾಸಕ್ತಿಗಾಗಿಯೋ ಅಥವಾ ಯಾವುದಕ್ಕಾಗಿಯೋ, ಇದನ್ನ ಬಗ್ಗೆ ಸ್ವಲ್ಪ ವಿಚಾರ ಮಾಡಬೇಕು ಅಂತ ನಾನು ಕೇಳ್ಕೊಳ್ತಾ ಇದ್ದೀನಿ. ಆಮೇಲೆ ಈ ಭ್ರಷ್ಟಾಚಾರ ಕೂಡ ನಾವು ಎಲ್ಲ ಕಡೆ ನೋಡ್ತಾ ಇದ್ದೀವಿ. ವಿಶೇಷವಾಗಿ ಈ ರಿಜಿಸ್ಟರ್ ಆಫೀಸಲ್ಲಿ ಒಂದು ಘಟನೆ ಹೇಳಬೇಕು ತಮ್ಮೆದುರಿಗೆ. ನಮ್ಮ ಒಂದು ಮನೆ ರಿಜಿಸ್ಟ್ರೇಷನ್ಗಾಗಿ ಹೋಗಿದ್ವಿ, ನಮ್ಮ ಚಿಕ್ಕಪ್ಪನವ್ರ ಮನೆ ರಿಜಿಸ್ಟ್ರೇಷನ್. ಅಲ್ಲಿ ಅವರು ಒಬ್ರು ಒಂದು ಲಿಸ್ಟ್ ಮಾಡಿಕೊಟ್ರು, ಪೆನ್ಸಿಲ್ ಇಂದ ಬರೆದು ಕೊಟ್ರು, ಇಷ್ಟಿಷ್ಟು ಕೊಡಬೇಕಾಗ್ತದೆ ಅಂತೆಲ್ಲ ಹೇಳಿ. ಅವಾಗ ನಾನು ಹೇಳಿದೆ, ನಮ್ಮ ಚಿಕ್ಕಪ್ಪನವರು ಸ್ವಾತಂತ್ರ್ಯ ಯುದ್ಧದಲ್ಲಿ ಅಂದ್ರೆ ಸ್ವಾತಂತ್ರ್ಯ ಸಂಗ್ರಾಮದಲ್ಲಿ ಭಾಗವಹಿಸಿದ್ರು, ಅಂಥವ್ರಲ್ಲಿ ಕೂಡ ನೀವು ದುಡ್ಡು ಕೇಳ್ತೀರಾ ಹೇಗೆ ಅಂತ ಕೇಳಿದಾಗ ಇಲ್ಲ ಅಷ್ಟು ಬೇಡ ಒಂದ್ ಸ್ವಲ್ಪ ಕೊಡು ಅಂತ ಹೇಳಿದ್ರು. ಆಮೇಲೆ ಸ್ವಲ್ಪ ಹೊರಗಡೆ ಬಂದ್ಮೇಲೆ ಒಬ್ಬ ಮನುಷ್ಯ ನಂಗೆ ಹೇಳ್ದ, ಅದು ಆ ಒಂದೇನು ದುಡ್ಡು ಕೊಡೋ ವ್ಯವಸ್ಥೆ ಇದೆ ಅದು ಇನ್ಸ್ಟಿಟ್ಯೂಷನಲ್ ಆಗಿಬಿಟ್ಟಿದೆ ಅಲ್ಲಿ. ಅವ್ರು ಕೇಳ್ತಾರೆ, ನೀವು ಓದು ಬರೆದು ಇದ್ದಿದ್ದ ಮನುಷ್ಯ ನೀನು, ನಿಮ್ಗೆ ಇಷ್ಟು ಗೊತ್ತಾಗೋದಿಲ್ವಾ, ಇದೆಲ್ಲ ಮಾಮೂಲಿ ಇಲ್ಲಿ ಕೊಡ್ಲೇಬೇಕಾಗುತ್ತೆ ಅಂತ ಅವ್ರು ಹೇಳಿದ್ರು. ಅಂದ್ರೆ ಅಷ್ಟು ವ್ಯವಸ್ಥಿತವಾಗಿದೆ ಅಲ್ಲಿ. ಅಂದ್ರೆ ಕೊಡದೇ ಇದ್ದವನು ಒಂದ್ ಸ್ವಲ್ಪ ಬೇರೆ ಚೆನ್ನಾಗಿ ನೋಡ್ತಾರ. ಒಂದು ಕೆಟ್ಟ ಅನುಭವ ಅಲ್ಲಿ ಆಯ್ತು ನಮಗೆ. ಆಮೇಲೆ ನಮ್ಮ ವಿಶೇಷವಾಗಿ ರಿಸರ್ಚ್ ಸ್ಕಾಲರ್ಸ್ ಇದ್ದಾರೆ ನಮ್ಮ ಯೂನಿವರ್ಸಿಟಿಯಲ್ಲಿ, ಎಜುಕೇಶನ್, ಫಿಲಾಸಫಿ, ಪೊಲಿಟಿಕಲ್ ಸೈನ್ಸ್ ಎಲ್ಲ. ಅವರು ಸಾಮಾನ್ಯವಾಗಿ ರಿಸರ್ಚ್ ಮಾಡುವಾಗ ಈ ಶೋಧ ಗಂಗಾ ಅಂತ ಒಂದು ವೆಬ್ಸೈಟ್ ಇದೆ, ಶೋಧ ಗಂಗಾ ಅಂತ ಹೇಳಿ. ಇಡೀ ನಮ್ಮ ದೇಶದಲ್ಲಿ ಎಷ್ಟು ವಿಶ್ವವಿದ್ಯಾಲಯಗಳಿದ್ದಾವೆ ಅಲ್ಲಿ ಏನು PhD ಥೀಸಿಸ್ ಸಬ್ಮಿಟ್ ಮಾಡಿದ್ದಾರೆ, ಆ ಎಲ್ಲ PhD ಥೀಸಿಸ್ಗಳು ಪೂರ್ಣ PhD ಥೀಸಿಸ್ ಅಲ್ಲಿ ಅವೈಲೇಬಲ್ ಇರ್ತದೆ. ಅಂದ್ರೆ ಸುಮಾರು 300 ಪುಟಗಳ PhD ಥೀಸಿಸ್ ಅಲ್ಲಿ ಅವೈಲೇಬಲ್ ಆಗ್ತದೆ ನಮಗೆ. ಈ ತರ ಇಲ್ಲಿವರೆಗೆ 4,50,000 PhD ಥೀಸಿಸ್ ಎಲ್ಲ ಅಪ್ಲೋಡ್ ಆಗಿದೆ. ಅದನ್ನ ನಮ್ಮ ಹುಡುಗರು ರೆಫರ್ ಮಾಡ್ತಾ ಇರ್ತಾರೆ. ನಾವು ಮೊನ್ನೆ ರಿಸರ್ಚ್ ಕೌನ್ಸಿಲ್ ಮೀಟಿಂಗ್ ಅಲ್ಲಿ ಕೂಡ ಹೇಳಿದೆ, ಆ ರಿಸರ್ಚ್ ಥೀಸಿಸ್ ಏನಿದೆ, ಆ ಶೋಧ ಪ್ರಬಂಧಗಳು ಅಷ್ಟಾಗಿ ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ ನಿಮ್ಗೆ ಸಿಗ್ಲಿಕ್ಕಿಲ್ಲ ಅಥವಾ ಅಥೆಂಟಿಕ್ ಹೇಳಲಿಕ್ಕೆ ಬರೋದಿಲ್ಲ. ಬಟ್ ನಾಳೆ ಎಲ್ಲವೂ ನ್ಯಾಯ ನಿರ್ಣಯಗಳನ್ನ ಡಿಜಿಟಲೈಸ್ ಮಾಡಿದ್ದಾರೆ. ಎಲ್ಲ ಹೈಕೋರ್ಟ್, ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ಗಳೆಲ್ಲ ಈ ವೆಬ್ಸೈಟ್ ಅಲ್ಲಿ ಸಿಗ್ತದೆ. ನಾ ಅವರಿಗೆ ಹೇಳಿದೆ, ತುಂಬಾ ಒಳ್ಳೆಯ ಬುದ್ಧಿವಂತ ನ್ಯಾಯಾಧೀಶರು, ನ್ಯಾಯಮೂರ್ತಿಗಳು ಅವರು ಜಡ್ಜ್ಮೆಂಟ್ ಕೊಟ್ಟಿರ್ತಾರೆ, ಅದೆಲ್ಲ ನಿಮ್ಗೆ ಅಲ್ಲಿ ಸಿಗುತ್ತೆ. ಪಬ್ಲಿಕ್ ಡೊಮೈನ್ ಅಲ್ಲಿ ಸಿಗುತ್ತದು. ಅದನ್ನು ನೀವು ಫಾಲೋ ಮಾಡಿದ್ರೆ ಒಳ್ಳೆ ಒಳ್ಳೆ ವಿಚಾರಗಳು ಸಿಗ್ತದೆ. ಯಾಕೆ ಹೇಳಿಕ್ ಬಂದೆ ಅಂದ್ರೆ, ಇಲ್ಲಿ ನಾನು ಹೊತ್ತಾಗಿ ಜಾಯಿನ್ ಆದಾಗ ಇಲ್ಲಿ ಒಂದು ಟೋಲ್ ಅಂತ ಸಂಸ್ಕೃತ ಪಾಠಶಾಲೆಗಳಿವೆ ಅಸ್ಸಾಂದಲ್ಲಿ, ಟ್ರೆಡಿಷನಲ್ ಓರಿಯೆಂಟಲ್ ಲರ್ನಿಂಗ್ ಸಿಸ್ಟಮ್. ಅದನ್ನ ಸರ್ಕಾರ ಮುಚ್ಚಾಕ್ಬಿಟ್ಟಿತ್ತು. ಇಲ್ಲಿ ತುಂಬಾ ಸಂಸ್ಕೃತದ ಪ್ರಚಾರ ಅಸ್ಸಾಂ ರಾಜ್ಯದಲ್ಲಿ ತುಂಬಾ ಇದೆ. ಸೊ ಅದನ್ನು ಪುನಃ ಉದ್ಧಾರ ಮಾಡಬೇಕಾಗಿದೆ. ಪುನಃ ಆರಂಭ ಮಾಡಬೇಕಾದ್ರೆ ನನ್ನ ಯೂನಿವರ್ಸಿಟಿಯಲ್ಲಿ ನನಗೆ ಡಾಕ್ಯುಮೆಂಟ್ ಸಿಗ್ಲಿಲ್ಲ, ಸಪೋರ್ಟಿಂಗ್ ಡಾಕ್ಯುಮೆಂಟ್ ಏನು ಸಿಗ್ಲಿಲ್ಲ. ಸೊ ನಾನೇನ್ ಮಾಡಿದೆ, ಗುರುನಾಮ್ ಗುರುಹು ಗೂಗಲ್ ಗುರು ಅಂತ ನಾವು ಹೇಳ್ತಾ ಇರ್ತೀವಿ ಹುಡುಗರಿಗೆಲ್ಲ. ಸೊ ಗೂಗಲ್ ಸರ್ಚ್ ಮಾಡಿದೆ, ಅಲ್ಲಿ ಎವಿಡೆನ್ಸ್ ನಾನು ಗೌಹಾಟಿ ಹೈಕೋರ್ಟ್ನ ವೆಬ್ಸೈಟ್ಗೆ ಹೋಗಿ ಅಲ್ಲಿ ನಾನು ಸರ್ಚ್ ಅಲ್ಲಿ ಟೋಲ್ ಅಂತ ಸುಮ್ಮನೆ ಟೈಪ್ ಮಾಡಿದ್ದೇನೆ, ಟ್ರೆಡಿಷನಲ್ ಓರಿಯೆಂಟಲ್ ಲರ್ನಿಂಗ್. ಅಲ್ಲಿ ಸುಮಾರು 2-3 ಕೇಸು ಇದ್ರ ಬಗ್ಗೆ ಆಗಿತ್ತು. ಸುಮಾರು ಒಂದು 20-30 ಪುಟಗಳಷ್ಟೊಂದು ದೊಡ್ಡ ಒಳ್ಳೆ ಜಡ್ಜ್ಮೆಂಟ್ ಸಿಕ್ತು. ಸೊ ಅದನ್ನು ಉಪಯೋಗ ಮಾಡಿಕೊಂಡು ಒಂದು ಒಳ್ಳೆ ಡ್ರಾಫ್ಟ್ ರೆಡಿ ಮಾಡಿ ನಾವು ಗವರ್ಮೆಂಟ್ಗೆ ಪ್ರಪೋಸಲ್ ಕಳಿಸಿದ್ವಿ. ಸಂಸ್ಕೃತ ಅಧ್ಯಯನ ಯಾಕೆ ನಿಲ್ಲಿಸಿದ್ರಿ, ಅದನ್ನ ಮತ್ತೆ ಮುಂದುವರಿಸಬೇಕು ಅಂತ ಹೇಳಿ ಆ ಪ್ರಪೋಸಲ್ ಈಗ ರೆಡಿ ಆಗಿ 97 ಪಾಠಶಾಲೆಗಳನ್ನ ಅವರು ಕುಮಾರ ಭಾಸ್ಕರ ವರ್ಮ ಸಂಸ್ಕೃತ ವಿದ್ಯಾಲಯ ಅಂತ ಅವರು ಮತ್ತೆ ಈಗ ಪುನಃ ಅದನ್ನ ಜೀರ್ಣೋದ್ಧಾರ ತರ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. ಸೊ ಯಾಕೆ ಹೇಳಿಕ್ಕೆ ಬಂದಂದ್ರೆ, ಈಗಿನ ಈ ಡಿಜಿಟಲೈಸ್ ಆಗಿರೋದ್ರಿಂದ ಸಾಕಷ್ಟು ಜಡ್ಜ್ಮೆಂಟ್ಗಳು ನಮ್ಗೆ ಗೌಹಾತಿ ಯೂನಿವರ್ಸಿಟಿ ಇದು ವೆಬ್ಸೈಟ್ ಆಗ್ಲಿ, ಕೋರ್ಟ್ ವೆಬ್ಸೈಟು ಎಲ್ಲ ಕಡೆ ಸಿಗ್ತಾ ಇದೆ. ಸೊ ಹಾಗಾಗಿ ನಾವು ಅದರ ಉಪಯೋಗ ಕೂಡ ಮಾಡಬೇಕು ಅಂತ ನಮ್ಮ ಹುಡುಗರಿಗೆ ಅವಾಗ ಹೇಳ್ತಾ ಇರ್ತೀನಿ. ಇನ್ನೊಂದು ವಿಷಯ ನಾನು ಹೇಳಬೇಕು, ಲಾ ಯಾವುದೇ ವಿದ್ಯಾರ್ಥಿಗಳು ಲಾ ಓದ್ತಾ ಇದ್ದಾರೆ ಅವರು ಸ್ವಲ್ಪ ಸಂಸ್ಕೃತವನ್ನು ಕೂಡ ಅಧ್ಯಯನ ಮಾಡಬೇಕು, ಸಾಮಾನ್ಯ ಅಧ್ಯಯನ ಮಾಡಬೇಕು ಅಂತ. ಯಾಕಂದ್ರೆ ಸಾಕಷ್ಟು ಪ್ರಾಚೀನ ಗ್ರಂಥಗಳು, ಧರ್ಮಶಾಸ್ತ್ರ ಗ್ರಂಥಗಳು ಏನಾದ ಯಾಜ್ಞವಲ್ಕ ಸ್ಮೃತಿ, ಮನುಸ್ಮೃತಿ ಇತ್ಯಾದಿಗಳೆಲ್ಲ ಸರಿಯಾಗಿ ನಾವು ಅರ್ಥ ಮಾಡಿಕೊಳ್ಳಬೇಕಾದ್ರೆ ಸ್ವಲ್ಪ ಮೂಲ ಗ್ರಂಥಗಳನ್ನ ಅಧ್ಯಯನ ಮಾಡಬೇಕು. ಯಾಕಂದ್ರೆ ತಪ್ಪಾಗಿ ಅರ್ಥ ಮಾಡೋದೇ ಜಾಸ್ತಿ ಇದೆ. ಈಗ ನಿಮಗೆಲ್ಲ ಗೊತ್ತಿರೋ ನಸ್ತ್ರೀ ಸ್ವಾತಂತ್ರ್ಯ ಮರ್ಹತಿ ಅಂತ ಒಂದು ವಿಶೇಷ ವಿಚಾರದ ಬಗ್ಗೆ, ಅದು ಒಂದು ಶ್ಲೋಕದ ಕೊನೆಯ ಭಾಗ, ಅದ್ರ ಬಗ್ಗೆ ಸಾಕಷ್ಟು ಕಾಂಟ್ರವರ್ಸಿ ಎಲ್ಲ ಆಯ್ತು. ಅದರ ಪೂರ್ಣವಾದ ಶ್ಲೋಕ ನಾವು ಓದಿದ್ರೆ, ಪಿತಾ ರಕ್ಷತಿ ಕೌಮಾರೆ, ಅದು ಪೂರ್ಣ ಶ್ಲೋಕ ಹೀಗೆ: ಪಿತಾ ರಕ್ಷತಿ ಕೌಮಾರೆ, ತಂದೆ ಎಂಬವನು ಆ ಹೆಣ್ಣು ಮಗಳನ್ನ ಬಾಲ್ಯದಲ್ಲೇ ರಕ್ಷಣೆ ಮಾಡ್ತಾನೆ. ಪಿತಾ ರಕ್ಷತಿ ಕೌಮಾರೆ ಯೌವನೇ ರಕ್ಷತಿ ಭರ್ತ, ಗಂಡನಾದವನು ಯೌವನದಲ್ಲಿ ಅವಳನ್ನ ರಕ್ಷಣೆ ಮಾಡ್ತಾನೆ. ಸ್ಥವಿರೇ ರಕ್ಷಂತಿ ಪುತ್ರಾಹ, ವೃದ್ಧಾಪ್ಯದಲ್ಲಿ ವಯಸ್ಸಾದ್ಮೇಲೆ ಮಕ್ಕಳು ಆ ತಾಯಿಯನ್ನ ಸಲಹುತ್ತಾರೆ. ಹೀಗಾಗಿ ನ ಸ್ತ್ರೀ ಸ್ವಾತಂತ್ರ್ಯ ಮರ್ಹತಿ, ಸ್ತ್ರೀ ತನ್ನನ್ನು ತಾನು ರಕ್ಷಣೆ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗೋದಿಲ್ಲ, ಅವಳಿಗೆ ಸ್ವಾತಂತ್ರ್ಯ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಅರ್ಥ ಬರೋ ಹಾಗೆ ಅದನ್ನು ಮಿಸ್ಇಂಟರ್ಪ್ರಿಟೇಷನ್ ಮಾಡ್ತಾರೆ. ಮನುಸ್ಮೃತಿಯೆಲ್ಲ ಬರುವಂತ ಇದೆ. ಅದೇ ಮನುಸ್ಮೃತಿಯಲ್ಲಿ ಒಂದು ಕಡೆ ಹೇಳ್ತಾನೆ, ಯಾರು ನಮ್ಮ ಮನು ಹೇಳ್ತಾನೆ, ಯತ್ರ ನಾರ್ಯಸ್ತು ಪೂಜ್ಯಂತೆ ತತ್ರ ರಮಂತೆ ದೇವತಾ, ಎಲ್ಲಿ ಹೆಣ್ಣು ಮಕ್ಕಳ ಪೂಜೆ ಆಗುತ್ತೆ ಅಲ್ಲಿ ದೇವತೆಗಳು ಕೂಡ ನರ್ತನ ಮಾಡ್ತಾರೆ, ಅವರು ಸುಖವಾಗಿರ್ತಾರೆ ಅನ್ನೋ ಹಾಗೆ. ಸೊ ಈ ತರ ನಾವು ಮಿಸ್ ಇಂಟರ್ಪ್ರಿಟೇಷನ್ ತುಂಬಾ ಜನ ಮಾಡ್ತಾರೆ. ಅದಕ್ಕಾಗಿ ಸ್ವಲ್ಪ ಸಾಮಾನ್ಯ ಜ್ಞಾನ ಸಂಸ್ಕೃತವೂ ಇರಬೇಕು. ಲಾ ಓದುವ ಎಲ್ಲ ವಿದ್ಯಾರ್ಥಿಗಳು ಸ್ವಲ್ಪ ಸಂಸ್ಕೃತ ನಾವು ಸಾಮಾನ್ಯವಾಗಿ ಹೋದ್ರೆ ಸಾಮಾನ್ಯ ಪರಿಚಯ ಇದ್ರೆ ಇಂಟರ್ಪ್ರಿಟೇಷನ್ ಸಂದರ್ಭದಲ್ಲಿ ತುಂಬಾ ಉಪಯೋಗ ಆಗ್ತದೆ. ವಸ್ತುತಃ ಆ ವಿಷಯದ ಬಗ್ಗೆ ನನಗೆ ಅಷ್ಟು ಹೇಳೋ ಅಧಿಕಾರ ಇಲ್ಲ, ಯಾಕಂದ್ರೆ ಇಲ್ಲಿ ಮಾತನಾಡಿದವರು, ಪ್ರಶ್ನೆ ಕೇಳಿದವರು ಎಲ್ಲರೂ ಈ ಒಂದು ಕಾನೂನು ಕ್ಷೇತ್ರದಲ್ಲಿ ತುಂಬಾ ಗಣ್ಯರಿದ್ದಾರೆ. ಕೇವಲ ಒಂದು ಅಭಿಮಾನದ ಮೇಲೆ ನಮ್ಮ ಇವರು ಮಹದೇವರು ನಮ್ಮನ್ನ ಇಲ್ಲಿ ಕರೆದ್ರು. ಸಂಬಂಧ ಏನಂದ್ರೆ ಕಲಬುರಗಿ ನಾನು ಕೂಡ ಮರ್ತೂರು ಸಮೀಪದಲ್ಲಿದೆ, ವಿಜ್ಞಾನೇಶ್ವರ ಜನ್ಮಸ್ಥಾನ, ಮತ್ತು ನಾವು ಕೂಡ ಹುಟ್ಟಿದ್ದು ಅದೇ ಗುಲ್ಬರ್ಗಾದಲ್ಲಿ ಕಲಬುರಗಿಯಲ್ಲಿ ಅಂತ ಹೇಳಿದ್ಕೊಂಡು ಅವರು ಅಭಿಮಾನದಿಂದ ನಮ್ಮನ್ನು ಕರೆದ್ರು. ಹೀಗಾಗಿ ನಮ್ಮ ಎಲ್ಲರ ಜೊತೆಗೆ ಕೆಲವು ವಿಷಯಗಳನ್ನು ಹಂಚಿಕೊಳ್ಳಿಕ್ಕೆ ನಾನು ಇಷ್ಟಪಟ್ಟಿದ್ದೇನೆ. ಇದನ್ನ ಇಲ್ಲಿವರೆಗೆ ಹೇಳಲಿಕ್ಕೆ ಆಯ್ತು. ಅದಕ್ಕೆ ಪುನಃ ಎಲ್ಲರಿಗೂ ಒಂದು ಸರಿ ನಮಸ್ಕಾರ ಹೇಳಿ ನನ್ನ ಮಾತನ್ನು ಮುಗಿಸ್ತೇನೆ. ನಮಸ್ಕಾರ.
ಕಾರ್ಯಕ್ರಮದ ಅಧ್ಯಕ್ಷ ಸ್ಥಾನ ಅಲಂಕರಿಸಿ ಅಧ್ಯಕ್ಷೀಯ ನುಡಿಮುತ್ತುಗಳನ್ನು ಆಡಿದ ಮಾನ್ಯ ಉಪಕುಲಪತಿಗಳಾದ ಪ್ರೊಫೆಸರ್ ಪ್ರಹ್ಲಾದ್ ಆರ್ ಜೋಶಿ ಅವರಿಗೆ ತುಂಬು ಹೃದಯದ ಧನ್ಯವಾದಗಳು. ವಿಜ್ಞಾನೇಶ್ವರ ಪ್ರತಿಷ್ಠಾನ ಮರ್ತೂರ್, ಕರ್ನಾಟಕ ಕೇಂದ್ರೀಯ ವಿಶ್ವವಿದ್ಯಾಲಯ ಕಡಗಂಚಿ ಕಲಬುರ್ಗಿ ಮತ್ತು ಕರ್ನಾಟಕ ಕಾನೂನು ವಿಶ್ವವಿದ್ಯಾಲಯದ ವತಿಯಿಂದ ಗೌರವಾನ್ವಿತ ನ್ಯಾಯಮೂರ್ತಿ ಡಾಕ್ಟರ್ ರಾಮ ಜೋಯಿಸ್ ರವರ 93ನೇ ಹುಟ್ಟುಹಬ್ಬವನ್ನು ಆನ್ಲೈನ್ ಸರಣಿ ಉಪನ್ಯಾಸಗಳ ಮಾಲಿಕೆಯಲ್ಲಿ ಮೊದಲನೇ ದಿನದ ಉಪನ್ಯಾಸ ನೀಡಲು ಕರ್ನಾಟಕ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ವಿಶ್ರಾಂತ ನ್ಯಾಯಾಧೀಶರಾದ ಹಾಗೂ ವಿಶ್ರಾಂತ ಉಪಲೋಕಾಯುಕ್ತರಾದ ನ್ಯಾಯಮೂರ್ತಿಗಳು ಸುಭಾಷ್ ಬಿ ಆದಿ ಅವರು ಮತ್ತು ಅಧ್ಯಕ್ಷತೆ ವಹಿಸಲಿರುವ ಅಸ್ಸಾಂ ಕುಮಾರ್ ಭಾಸ್ಕರ್ ವರ್ಮಾ ಸಂಸ್ಕೃತ ಮತ್ತು ಪುರಾತನ ಅಧ್ಯಯನ ವಿಶ್ವವಿದ್ಯಾಲಯದ ಮಾನ್ಯ ಕುಲಪತಿಗಳು ಕಲಬುರಗಿಯವರಾದ ಪ್ರೊಫೆಸರ್ ಪ್ರಹ್ಲಾದ್ ಆರ್ ಜೋಶಿ ಅವರು ಹೃದಯಪೂರ್ವಕ ಧನ್ಯವಾದಗಳು. ಕರ್ನಾಟಕ ಕೇಂದ್ರೀಯ ವಿಶ್ವವಿದ್ಯಾಲಯ ಕಡಗಂಚಿ ಕಲಬುರಗಿ ಮತ್ತು ಕರ್ನಾಟಕ ಕಾನೂನು ವಿಶ್ವವಿದ್ಯಾಲಯದ ಮಾನ್ಯ ಕುಲಪತಿಗಳು, ಉಪನ್ಯಾಸಕರು ಹಾಗೂ ವಿದ್ಯಾರ್ಥಿಗಳಿಗೆ ಧನ್ಯವಾದಗಳು. ಅನ್ಯಾನ್ಯ ವಿಶ್ವವಿದ್ಯಾಲಯಗಳ ಮಾನ್ಯ ಉಪಕುಲಪತಿಗಳವರಿಗೆ, ವಿಶ್ವವಿದ್ಯಾಲಯಗಳ ಅಂತರ್ಗತ ಬರುವ ಕಾನೂನು ಮಹಾವಿದ್ಯಾಲಯಗಳ ಮತ್ತು ಅನ್ಯಾನ್ಯ ಮಹಾವಿದ್ಯಾಲಯಗಳ ಪ್ರಾಚಾರ್ಯರು, ಉಪನ್ಯಾಸಕರು, ವಿದ್ಯಾರ್ಥಿಗಳಿಗೆ ಧನ್ಯವಾದಗಳು. ಮಾನ್ಯ ನ್ಯಾಯಾಧೀಶರು ಹಾಗೂ ನ್ಯಾಯವಾದಿಗಳಿಗೆ, ಪ್ರಾಸ್ತಾವಿಕ ನುಡಿ ನುಡಿದ ವಿಶ್ರಾಂತ ರಾಜ್ಯಸಭಾ ಸದಸ್ಯರು ಮತ್ತು ಪ್ರತಿಷ್ಠಾನದ ಮಾನ್ಯ ಅಧ್ಯಕ್ಷರಾದ ಶ್ರೀ ಬಸವರಾಜ್ ಪಾಟೀಲ್ ಸೇಡಂರವರ ಸ್ವಾಗತ ಮಾಡಿದ ಶ್ರೀ ಶರಣಗೌಡ ಪಾಟೀಲ್ರಿಗೆ ಮತ್ತು ವಿಜ್ಞಾನೇಶ್ವರ ಪ್ರತಿಷ್ಠಾನದ ವಿಶ್ವಸ್ತರೆಲ್ಲರಿಗೂ, ಉಪನ್ಯಾಸ ಯಶಸ್ವಿಗಾಗಿ ಪ್ರತ್ಯಕ್ಷ ಪರೋಕ್ಷವಾಗಿ ಸಹಕರಿಸಿದ ಎಲ್ಲರಿಗೂ ಧನ್ಯವಾದಗಳು.
ಸರ್, ಎಲ್ಲರಿಗೂ ಧನ್ಯವಾದಗಳು. ಟೆಕ್ನಿಕಲ್ ಅಸಿಸ್ಟೆಂಟ್ ಕೊಟ್ಟಂತ ಸಂಶೋಧನಾ ವಿದ್ಯಾರ್ಥಿಗಳಾದಂಥ ಕೃಷ್ಣ ಮತ್ತು ಕುಮಾರಿ ರಾಗಿಣಿ ಅವರಿಗೂ ಕೂಡ ಧನ್ಯವಾದಗಳು. ನಾಳೆನೂ ಈ ಕಾರ್ಯಕ್ರಮ ಇರುತ್ತೆ. ನಾಳೆ ತಾವೆಲ್ಲರೂ ಜಾಯಿನ್ ಆಗಬೇಕು ಈ ಕಾರ್ಯಕ್ರಮದಲ್ಲಿ. ನಾಳೆ ಮತ್ತು ನಾಡದ್ದು 3 ದಿನ ಇರುತ್ತೆ. ಅದಾದ ನಂತರ 3 ಮತ್ತು 7ನೇ ತಾರೀಕು ಮತ್ತೆ ಇರುತ್ತೆ. ಈ ಕಾರ್ಯಕ್ರಮದಲ್ಲಿ ಭಾಗವಹಿಸಿದಂಥ ಎಲ್ಲ ಗೌರವಾನ್ವಿತರಿಗೆ, ವಿದ್ಯಾರ್ಥಿಗಳಿಗೆಲ್ಲರಿಗೂ ವಿಜ್ಞಾನೇಶ್ವರ ಪ್ರತಿಷ್ಠಾನದ ಪರವಾಗಿ ಧನ್ಯವಾದಗಳು. ಈ ಕಾರ್ಯಕ್ರಮ ಅನುಕೂಲ ಮಾಡಿಕೊಟ್ಟಂತ ಕೇಂದ್ರೀಯ ವಿಶ್ವವಿದ್ಯಾಲಯದ ಕಾನೂನು ವಿಭಾಗದ ಡೀನ್ ಶ್ರೀ ಬಸವರಾಜ್ ಕೂಕಟ್ಟಿ ಅವರಿಗೂ ಧನ್ಯವಾದಗಳು.
ಥ್ಯಾಂಕ್ ಯು ಸರ್.
ಧನ್ಯವಾದಗಳು ಸರ್. ಸರ್, ಧನ್ಯವಾದಗಳು. ಎಲ್ಲರಿಗೂ ಕಾರ್ಯಕ್ರಮ ಮುಕ್ತಾಯವಾಯಿತು. ನಾಳೆ ಮತ್ತೆ ಭೇಟಿಯಾಗೋಣ.